All right, good evening, everyone. Can someone confirm that they can hear me?
We can hear you.
All right,
Yes,
thank you
I
very
can
much.
hear you.
All right, thank you very much. Good evening. Good evening. My name is Dennis Williams, and I will be your moderator for today. Thank you so much for joining in for today's session. Our topic for today is IP for creatives and innovators, and I'm sure we would have a very exciting session. I'm sure we would have a very exciting session. I can see that one of our mentors has joined in already. So not to waste any further, one or two of our mentors have joined in already. So not to waste any further time, let's just go ahead to introduce our mentors. Okay, to save time, we will not be reading the profile of all our mentors because quite a number of the mentors we'll be having on call today were present in the previous class, but we have two new faces, so we'll be reading their profiles in full, and then for the rest, we'll be reading just a line or two of their profile just to give them proper introduction. So starting off with that, our first mentor for today that we expect in this session is Miss Regina Owumere. Owumere. Sorry, Ma, if I didn't pronounce your surname very well. Miss Regina is a senior asset in Aluko and Oyebode. She has a robust experience in IP prosecution and related practice garnered over the years. Regina is a Harvard alumni and she graduated from the University of Nigeria, Nsukka, with an LLB honors in 2012 and the Nigerian Law School in 2013. Regina was nominated to serve in the International Trademark Association Committee for the 2022-2023 term, in addition to being selected as an outstanding trademark and patent practitioner in the WIPR Leader Guide 2021. Regina is extremely passionate about intellectual property law and policy and how IP affects clients' business. I don't think Miss Regina is yet here with us, but I'm sure she will be joining us soon, and I'm sure we'll be learning from her vast knowledge and experience. The second mentor we expect in today's class is Miss Kodichi Anigogu. Ms. Kodichi is an astute legal professional with a wealth of experience in commercializing intellectual property and in data protection. She is involved in various facets of these areas of law, from advising clients on identification and exploitation of intellectual property rights to preparing documents for IP transaction. She also conducts training on intellectual property and entertainment law. On the data protection front, she holds a CIPP/E qualifications from the International Association of Privacy Professionals. She advises on data protection law and conducts data protection audits and training. Kodichi has authored several articles on intellectual property and data protection and is a contributor to the Thomas Rotter Digital Business Global Guide for Nigeria. Kodichi is an associate in the prestigious law firm of Jackson, Etsy, and Edu. Thank you, Ms. Kodichi, for joining. I can see you are already here with us on call. We look
Thank you
forward
very
to
much.
we look forward to learning from you in today's session. Um, our third mentor that we expect here on call, like we had last week, is Mr. Folarinwa Aluko. Folarinwa Aluko is a legal practitioner and partner in the firm of Truman Rockwood Solicitor, where he provides advisory and consultancy services to companies and a wide range of creators, users, and startups. Like I said, for the mentors that we had last week, I'll just be taking a bit of their profile so that we don't spend a lot of time reading profiles. Thank you, Mr. Folarinwa, for volunteering to be here and educate our mentees. Our third or fourth mentor, rather, that we expect in today's class or that is already here is the wonderful Miss Amusa Shukurat Modupeola. Shukurat is a seasoned intellectual property consultant, analyst, and educator with public sector experience. She holds a master's degree in intellectual property from the prestigious Africa University Zimbabwe in collaboration with WIPO and the Japan government. Welcome, Ms. Amosa. Thank you for joining us in today's session. Okay, I've gone through Ms. Regina. The other mentor we are expecting in today's class is Mr. Sand Umbakalu. Sand Umbakalu has over 15 years experience in implementing international development programs in geographics indication, GIs, international trade and investment, trade policies, research, policies reform, market access, monitoring and evaluation, capacity building, market linkage, and value chain. Mr. Sand, like we already introduced him in the last class, is very well vested in IP. So we will not be going further with reading his profile. So thank you, Mr. Sand, for joining in for today's class. Another mentor that we are going to be having today is the wonderful Mr. Max Ikombe. Mr. Max Ikombe is the founder / principal of Everlaw Associates. He works extensively in the fields of arbitration, ICT/technology law, and intellectual property. Max is a facilitator on the annual Information Technology and the Law course of the Nigerian Institute of Advanced Legal Studies since 2016. He has trained in advanced intellectual property. He has trained in advanced intellectual property law courses at the World Intellectual Property Organization Academy. He is an accredited agent of the Nigerian Trademark and Patent Registry and has conducted IP registration business there since 2010. Our last but not least on our mentors that we'll be having in today's session is Ms. Onyekachi Eriobu Aniede. Onyekachi, a lawyer and former TV presenter, joined the Nigerian Civil Service in 2014 and was posted to the Commercial Law Department, Federal Ministry of Industry, Trade and Investments, the office mandated to protect industry property in Nigeria. Thank you to Ms. Onyekachi. We expect her to join us very shortly. I'm sure that we are going to have a power-packed section. Our wonderful mentors are already, some of them are already here with us on call, and they are going to be taking us through the subject matter of today. But so before we go into that, for the sake of the lighting in some of our backgrounds, like my own location is quite dark. So I would like to ask that we turn on our videos so that we can take a quick screenshot and then move on with the class. So please, if you can, and if you're in a well-lighted background, please turn on your videos so that we can take a quick screenshot and then move on to this session. Thank you, Imal Bong Brown. Thank you, Mercy. All right. All right, thank you very much. We are done with that. So not to waste any time, we'll be giving the floors to the mentors we have with us. And then as our other mentors join in, we'll be giving them the opportunity to run through their own presentation on the subject matter for today. Like I earlier said, our topic for today is intellectual property for creatives and innovators. So I would like to call Ms. Kodichi. Ms. Kodichi, please, the floor is yours. We would like to give you roughly 15 minutes for your opening introduction and presentation into today's topic. You're welcome, Ma.
Okay, thank you very much. Pleasure to be here. Hello, everyone. I'll just put my slide up and we'll quickly go through it. Can someone just confirm that they can see it and they can see it fine?
I can see it's fine.
Yes, I can
Thank
see
you.
it.
Okay, all right. So I'll really touch on intellectual property, its definition, and we then go into various types. Now, just to start with, right, I'd like to hear from all of us that are, mentees that are present in relation to these two IP scenarios that are here. So we have first one is the 15-year-old. I don't know those of us that have heard the news. I've heard about this because this Herman Bekele was named Times Kid of the Year, and he's developing a soap that can actually cure skin cancer, which is, that also, okay, my slide keeps changing. I need to fix that. Yeah, so I don't know if anyone could, quickly unmute and, let's just hear what type of IP rights you think would come up in, someone developing a soap that can actually cure skin cancer. Is anyone able to unmute?
Yes, I might be wrong, but then could patents be applied to an invention like that?
What did you say? Can you take that again?
Can patents be applied to that
Exactly.
invention?
Exactly, great. That's a great response, right? Because this is something, and that's what we'll look at further along in the slides. That's what patent is doing. It's looking at new activity, something inventive, something that hasn't been done before, something that is kind of that doesn't exist. It's an invention that just that has come up and arisen as from one's, thinking and development, which is really what IP is about, which is what IP also is celebrating. So the second one, we just have a picture here. We have Ame Egu's line-based painting. So this is a painter, an artist that uses lines, in his drawings. And I just want to hear what type of IP anyone thinks would come under. What does painting fall under? What form of intellectual property does painting fall under? Yeah.
Would that be a copyright? Copyright.
Great. Who wants to say what type of copyright? You can say as well.
Artistic
Great.
creations.
Exactly, artistic works, perfect. So under copyright, there are also still different types. Guys, I don't know if on your end the slide keeps moving, but I every time it's taking me to the next slide. I don't know why. So bear with me. I'm not the one. Yes, I'm not the one doing that. It's just happening. So I noticed that we're saying, we're talking about IP rights for creators and inventors, or, creatives and innovators. And in terms of the terminology, right, it's like, is it the same thing? Is it a different thing? But really, it's not, in general use of language, those of us that are, lawyers and those that are in law school or those that are studying law and we may be in other courses, but general use of language, right, it could apply to the same thing. It's talking about new development, right? But for the law, statutorily, they are used in different contexts. So you hear more of invent in relation to the Patents and then Designs Act, and then creators would come up in the Copyright Act, right? And then there's some sort of difference that I would identify, because under the copyright, not everything can be, what is copyrightable. And some of us may have learned so far that, ideas can be copyrighted. But the interesting thing in patents now is that it also protects and protects ideas and methods and applications, ways to do things, solving equations, which you would not find under copyright. So I just wanted to point that out. Then we'll go into the next slide, just defining intellectual property really. And the nice thing, at least for intellectual property and copyright, is that when you hear it, you can kind of guess, okay, rights to intellectual property, copyright rights, to copy things along that line, right? But to split it further, we're saying intellectual. Intellectual speaks to mental, speaks to creativity, so it's a product of one's mind. And that property aspect, connotes that ownership aspect to it. So unlike, tangible property that you would have, you have your laptop or your phone that you're listening to, for instance, to this, those are tangible. You can see you could hold, but intellectual property tends to be intangible. So it is not the product. For instance, I mentioned the computer now. Computer, or no, let's use the example, the cure for cancer now, right? If it's sold as a product, at the moment for skin cancer, it's there's a treatment and it's in a cream base, but this person is developing it in a soap. So that soap itself, would be a product. For intellectual property, the interest is not, in that is that intangible aspect, that right of ownership, which you can't see, the same way that when we talk about copyright, you may hear, oh, you take someone's book. It doesn't mean you have the copyright in the book. Someone gives you a book. It doesn't mean that, you can go ahead and start making copies of the book, that the book is yours. So that aspect within that product, and like we also established, it can be a process, that aspect is what is protected as a property, right? The content in a sense, and not the form in which it is provided. Let me use that. Right. So what intellectual property right does, it's not with the exception of trademarks, intellectual property does not last for forever. They are all timed. So it gives the creator exclusive control for a limited period of time. The timing varies depending on the type of IP it is, but it is not forever. So we have our divisions of intellectual property on the screen now, split into, copyright, then split into industrial property. And then under industrial property, we have our patents, we have our trademarks, and the likes. So looking at copyright now, copyright is the exclusive right to control certain acts, specific acts for certain creative works. We already identified the painting now as an artistic work, but under copyright, there are 6 types of works that are recognized. We have literary work, artistic, musical work, sound recording, audiovisual work, and a broadcast. Right. So for literary work, as the name implies, literature. So your poetry, your prose, even your lyrics in a song, the specific writings. Then also we have for computer software, your coding, your scripts for a play, things along that line, all that is written, prose form, their literary works. For artistic works, we already identified painting, talking about photography, we're talking about architectural models and things along that line. Then we have musical work. So anything work that is published or that is created, for musical accompaniment, musical notes, sheet music, something that is to be, to be developed into music, created for that purpose. That's a musical work. So your beats, rhythm, things along that line. Then we also now have the sound recording. And prior to the new Copyright Act, prior to 2022, the older Copyright Act kind of differentiated a musical sound recording in terms of ownership from a normal sound recording. But now we simply have sound recordings of whatever type, which is, me speaking now, and if it's being recorded as a sound recording, voiceovers, any audio, your podcasts as well. Those of you that may have podcasts, that's a sound recording a song, listening to your favorite artist music. What you're listening to is a sound recording things. Those are sound recordings. We also have audiovisual works. Prior to the 2022 Act, they were called cinematograph films. And this is basically any, motion picture. So the combination of visual and sound, it can even be silent film, but that emphasis on the visual, and it's a continuous play of it. So that's what distinguishes it from a picture. It's a picture in motion. So those are audiovisual works. Then you have your broadcast. And broadcast relates to streaming or signaling, right? Communication of signal that is being heard at the same time, right? Because it's distinguished from a general audiovisual work in the sense that it's going to be being able to play all that. The focus on broadcast is that it's happening live and that you're not able to, at a later occasion, listen to it or access it. That's kind of what distinguishes broadcast from, having just your audiovisual work and things along that line. Okay, I think have stopped moving. It's now common. So we look at these, we've identified these 6 different types of works and what falls under them. And we then go into what makes them, what makes work eligible to have that protection, because copyright is giving a protection, a right to copy, giving a protection to anybody as a creator, we're talking about now, developer, anybody like the person that did the paintings. If you sing a song now, if you write a story and all that, what actually makes it entitled to protection is not automatic. it has to be eligible, falling under any of the 6 work, and then also being original and being fixed. So when we talk about originality, what we're saying is that effort must go into the creation, into expressing it. And that's why you have heard that ideas are not copyrighted. If we say boy meets girl, boy falls in love, boy and girl marry, that's not anything. But when you start putting things around it, what's the boy's name? Where does he live? Do they live in Nigeria? Or what happens, is it a Romeo and Juliet situation, where, someone ends up taking poison? When you flesh it out, it becomes what is not the usual and what is not just, an idea, because everything is, has been done under the sun. But what is done to now make it original? How do you bring it home so that I'm watching your Nollywood film and I'm not seeing another Nollywood film? How has this been distinguished? They might all have the same trope. That's what we might call them, like a rags to riches situation, a rags to riches story. But what distinguishes it? Where is it happening? Where is the protagonist poor? When does the person become rich? How does the person even make that money? Does he find money on the floor, or does he work hard and succeed? Those things, those efforts and expressions are what now brings that originality aspect and will differentiate you from, work from another work. Then we now look at fixation, which says that your work just has to be fixed in a definite medium. So if I come here and I talk and it's not recorded and I tell you all this great story, but then, it's not fixed, it's almost like saying there's nothing to protect. And that was why we had to, create things like, just stepping out a bit now from copyright, when we look at things like traditional knowledge, protecting it, because normally there are things that are handed down and they're not usually written. So it's almost like they would not get protection because of elements or because of requirements, like this. But for copyright as it stands, you want your song, you have to write your lyrics out. You want, you have to write your sheet music. So anybody that's playing it on an instrument knows which tone to follow. You have that defined. You want to, create something artistic, you have to draw it out. It just has to be fixed. It just has to put into a context, into a mode for it to then be used and for it to then be protected. If not, it's, up in the air, so to speak. So there are many, many rights under copyright. And that's another thing that I just want to share, for creatives that are also listening beyond the legal aspect. You're designing or you're creating something, you're writing something, you're a songwriter, you want to sing, you want to write a book, whatever it is, you're a skit maker and the likes, there are different rights under copyright, and those can actually have commercial benefit to you, because if you want to then make money off it, you don't have to give everything at once. You don't even have to change ownership. You don't have to transfer ownership. You can decide to license, and then you don't have to license everything. For instance, we're looking at reproducing, publishing, or performing in public. You can tell another person, okay, this is my, short film. You can show it, in public, and you can tell someone else, oh, make copies of it in whatever format, and sell. We used to have CDs, in those days. It's been a while, things like that, but people are able to, do digital downloads and the likes. Those are rights, those are copyrights that are controlled. And even in terms of streaming, so the new Copyright Act has enabled it, even though, yes, streaming prior to now under the old law could fall under, any of the provided rights. It is now come and been stated expressly that, making available to the public via wire or wireless means in a way that they can access the work from a place and time individually chosen by them. So your favorite show, you want to stream it and, you have class and you don't want to do that to 5 p.m. or you have work, so you're going to do it by 8. The ability to be able to determine the time you will watch this, it separates it from the definition of broadcast and given earlier, but then it's also a right that is controlled by the owner of the work, or for instance, even the musician and things like that, So making an adaptation, those of us that know Yemi Alade, she might do a song in English and the next thing she has a song in, in French, things like that, changing it and making it different is because you have those rights that you are able to do it. So that's a very important thing to note in terms of making money. Don't feel like, you one and done. You can sell this script and say, oh, don't and you have like, friends Nigeria was surrounded by Francophone countries. Like, okay, well, I want to publish my book in this other country. You go and meet a different publisher, and then they pay you a different money because they're going to be publishing it in French. Meanwhile, in Nigeria, like this other publisher is selling it in English and something, just like that, these things are spread, and that's the benefit and the beauty. And also we have, like I mentioned, it's protection for a time, not for all time, so to speak. So we have here for literary work, musical work, and artistic work. Those are linked to people. Those are linked to creators, directly, even if it's not just one person, even if it's more than one person. So the lifetime of the author, so 70 years after the author's death is how long you can have it. But for things like, film, photograph, and the likes, it talks about the publication, 50 years after the publication. So also for sound recording, for when it is published. And something else the law makes clear, which is very beneficial, because we're talking now, I know there was another session on IP for businesses. So now we're talking about, creatives, we're talking about inventing. So we're looking at it as the individual, which is what is, the law is very, the Copyright Act is very pro-creator. You understand? It's pro-individuals than even in terms of a company, unless you are now the one relinquishing or assigning of your right. But there are many instances where where you create and you are the one that owns it initially. So what that also does is it gives you a very good bargaining ground. It gives a lot of benefit. And I'll use, for example, the United States copyright law. So for them, there's something called referred to as work for hire. And that basically says, if I commission one of you here, to write a song, because I have said, okay, write a song for me, it's my 30th birthday, I want to celebrate, create a song and everything for me, because I've given that instruction, and of course, I'm paying and the likes, that ownership would shift. But under Nigerian copyright law, what we enjoy now is if I tell someone to do that, they are still the owner. If someone here writes a song for me and the likes, let me see any names in the head of Dara, writes a song that I like it. Dara is the owner, so Dara can still determine, pay me this, pay me that in fact, this song, I want to use it and do something else. I'm going to adapt it. In fact, there could be a movie about it, just a little. You have that ability to, turn things into what you want, which is what the law allows, subject to contract. But in some other jurisdictions, it's not the case. So creators have a very good grasp or are highly favored under the Nigerian law, which is something that was very key to mention. Though what even happened now is that the new Copyright Act allows you to have a license. So if I was to commission, I'd mentioned Dara now for the song. So I get to, use it for my party, or use it to, celebrate and the likes. I just have a license. But Dara is still free to exploit it any other way she wants, unless we have contracted. And that's very important. So as I earlier mentioned, copyright can be assigned, it can be licensed, it can be transmitted by occasions of law and the like. So there's a lot of fluidity for our creators out there. There's a lot of benefit to them. And there's something else that I have to mention is that even in relation to the formal stage, and that's what distinguishes copyright from the other forms and the industrial property, other forms of intellectual property known as industrial property, is that it exists, immediately the work is created. So you already kind of have that protection, but we would always advise, documentation is key, even as, fixation is one of the elements for the work to be eligible for that copyright protection. It has to be fixed. So also, filing your work with the Nigerian Copyright Commission can help you with that protection, because where there are two competing claims, you're able to see, see proof, this was made in the year 2022, this, that, and you have your certificate on record. But that benefit as well is the good part of copyright, in the sense that once it comes into existence, it is already protected. We'll talk about performance rights, and it's kind of referred to as neighboring right. It's not, a copyright per se. And performance rights used to be strong in the old act and all, but there's actually been improvements. It's been defined now. So we're looking at, our actors, we're looking at our singers, musicians, and our dancers. Because sometimes there's some misconception. If you hear a Davido sings, you think it's like a copyright situation. No, it's not a copyright situation, because for example, what Davido song now? Let me use Fire. That's the word that comes to mind, and the likes, then we have to go back looking at our different types of copyrights from the sound recording, who is the record company, because the ownership changes in relation to, what type of copyright work it is. So is someone speaking? So for a sound recording, the owner be the person that, made the arrangements for the song. And usually that would be the record label. Most record labels will want to enter into contracts where they're the ones, financing recordings and creation of masters and songs and things like that. So that sound recording now for Davido's Fire, would belong to, I think, OBO, what's the name of his, Teddy BJ? I don't know which one is the name of the record label. There's that. But then who wrote the lyrics, the beats, who composed the song? That's another work. That's the musical work. That's another IP right. So you're not even going to call unless it has been assigned to him. We can't say that Davido is the owner of Fire unless it's assigned, because he's not the creator. So Davido's own rights comes in here under this performance rights. So think of it in any sense, Beyonce, any of your favorite, artists. And that's why sometimes you hear when they talk about themselves, you hear something like singer-songwriter, because it means different things. So this performance rights, right? We're talking about dancers. And I noticed, I think one of the presentations, one of the groups will be doing, they talked about the choreography and the like. So it was very important that it was identified that, dancers are performers, and then they also have rights, so they have exclusive rights to, their performance, to the recording. So if, I was to perform, even if I'm performing another person's song, who has the right to record me carrying out the performance and the likes? Performers can't control that. It's different from, the music being sung and things along that line. That right is, distinguished. And, if you're going to be reproducing the performance, if it's a choreographer, it's a dancer, in any form, that particular movement, right, actually going to replicate it can actually get one in trouble. So we know that the duration for performance rights is a period of 50 years. There's something else also that the new law has done. Prior to now, the right to receive credit. So for the copyrights that we've all identified, the 6, and for those that create them, for instance, and the person that, writes the stories, person that writes, creates the painting, that draws up the painting, the person that takes the photo and things along that line, right? They have a right to be credited and identified. This is you have to credit them correctly. You can't make a mistake and say the picture I shown you earlier was drawn by, Kodichi, instead of, the name identified and things like that. So what has now happened? Prior to now, performers didn't have a right to be credited. So that was interesting, because it's like, oh, you're watching a movie, you can see that it's RMD or, Ramsey Noah or something. But then if it's not stated as Ramsey Noah and is misnamed, they didn't necessarily have a right under, the law to say, you must credit me and, correct the error and things like that. But what has happened now is that the right to be credited has been, identified and stated plainly in the law. So, maybe we expect cases or expect things like that where people are speaking up on, oh, you didn't write my name, you didn't state that I was the one in this, and, things like that. So that's like a really good development. It's bringing performers up to that level where, those creators or like our songwriters or composers, our artists tend to be, which is really good. So we'll just look also now quickly at industrial opti, like I mentioned, is the other aspects. It looks at protection of a wide range of industrial and commercially valuable information. So we're looking at inventions, we're looking at designs, we're looking at trademarks, we're looking, of course, at patents. So I'll just pick the trademarks, and I want to try and tie everything still to individuals, because I don't want the focus to now become on businesses, right? But even as we are here, some of us may find that, we have things that we're doing and that we have names, for instance, that we are known for, even using it, right? Different from your different from your, your government name, to use that word. For instance, I'm giving them Davido, but his name is David Adeleke or something like that. So this name, he's known as Davido in performing the business, of being a performer, of being a musician and things like that. So when you have a trademark, it is what is used to identify, it is a mark that identifies your trade. So any of us here, you might be, making bags, you might be, an actress as well. You could be making skits and, there's a particular name that you get called in your skits and things like that. If it is being used to identify that brand, used to identify that entertainment service, used to identify that is actually a trademark. And, definitely to ensure you have that protection, it's always good to register. Because I would just mention that there are also some common law rights where, you may not register, but it's so popular, everyone knows it's you. But some of us have not maybe lived long enough or worked long enough to have that. So the thing that would always be the advice, and of course, the best thing is registration, because that is what confers rights, especially with industrial property. So these are marks that are used in trade to distinguish goods, from a particular person. So Davido's song, Burna Boy, those kind of things and the like. So they can be anything. I've used names. They can actually be, symbols or shapes. And let me use record labels as well, because we have some record labels that actually have a design in how they do it. And even those that, produce some music videos as well, there's a way they tend to write their names, things like that. So even using that shape, is a trademark. So you see this and you just automatically, recognize it. I have here this is Liverpool's slogan. So footballers would, you see this and you're already, you're talking about Liverpool, just you never walk alone, that slogan, and then it sticks. So trademarks can be a lot of things as long as it serves that purpose of, identifying a brand. And then we get some questions like this in relation to, trademark being different from a company. And, some people would be like, oh, I've registered my company name. Is that not enough? But what typically happens is that a company is just, the name you're using to do the business, the incorporated name, the legal entity name. But most companies have different products. For instance, we have, what comes to mind now? Maybe even the Sterling Bank, and each Sterling Bank has its 823 for, the mobile banking or something, or EcoBank with the 324. There are different types of products, and then they have their EcoBank Advantage, or Wema, and then there's Alert. There are different things. So their companies are always developing products. For instance, we have our Gala brand, right? But then they're always developing these things. So these trademark names would be for your product or your service. It's different from the company, itself. So usually, companies can have one or more trademarks. Individuals can have one or more trademarks. If you're multi-talented, you're doing different things. There are some people that even trademark, the names of their songs or things like that. If they really stand out, how they are written. We have people that trademark the names of films that they do, depending on the popularity and what you can also use it to do. For instance, I don't know if those of us here that watch them King of Boys, if we notice, we started seeing them KOB Army shirts and things like that. Those are like merchandising and things where the name of a film is being used to even generate more money, but then it stands alone and it's a Kemi Adetiba film or things along that line. It's separate from that person. It becomes a brand and it stands, alone. So like I mentioned, trademark is that one right that stays forever, as long as you keep, renewing. It's an evergreen right, and the more you use, the more benefit to you. For instance, now another person that definitely, is a strong trademark, I would say is Sabido's, right? That's not his real name, but that name, you go and then you protect it because it is being used, for like entertainment, for comedy, things along that line. So that's the best way to protect them, aliases, if you're in the entertainment industry and the likes, next to your real name. So looking at patent is where we are looking at and developing a product or a process, that has never been done before, never been seen before, and it doesn't just have to be a product, it doesn't just have to be a product, it can also be a process, unlike with copyright, where things like, methods, calculations, and all that are not allowed. You can actually use patent to protect processes. For instance, in making textiles now and in creating fabric, there are actually several patents around that. And I think, especially speaking to this point now on inventors, and innovators. We need to do a lot of that, maybe in, developing worlds, in Nigeria, in Africa, things along that line, where people can, you can sit down and actually devise, okay, there's this need, because patent is about solutions to problem. So it's identifying that there is this problem and what can it do? And quite frankly, it doesn't have to be the hardest thing in the world. The safety pin that we're using now and pinning clothes and all that, you can't really thinking about it now. It's a patented product, but it's not like, the hardest thing in the world to come up with. It's a solution, right, to a problem. And it can be what? So the three elements, it has to be new, which means it hasn't been done before. It has to be inventive. So thinking about, the metal, taking it, folding it like that, creating that flap and doing all of that to enable you to be able to clip and unclip. Is that, it's not state of the art, it's not the usual. Anybody wouldn't have just, gone to think about it, but this was the problem that was trying to be solved, and then it can be replicated. So those are actually elements to patents. And I feel like I just want to encourage our young inventors. And that's why I made sure that I brought that slide on Hakeem there and what he's trying to do with soap, right? That we should be able to think outside of the box. People are always talking about China, the young people in China are always, sitting down, they put them in the classroom and it's like, make this, make that and all that. But we have to also need to have those abilities to develop and invent things. What is a problem that we can find a solution to? And I must mention, it's almost like a cheat code. Because of the way the system is in Nigeria, we do not do what we call substantive examination. I just want to check that we are all following. So can someone tell me, does anyone have an idea what that means?
No.
Okay, so you're speaking for everybody, right?
No, not everybody. It's for me.
Just for you, okay. Does anyone want to try? I'm also checking the chat box just in case.
Probably the patentability of maybe your application or what you want to patent, really.
You want to check if it's ahead, if it has not been done before, if it's truly as as you're saying and all that. So what happens is that currently, as it speaks under the Nigerian patent, we don't have that. And while yes, in the future, because if someone comes and says, oh, this is something, and all that, the registry, as the government has the right to say, oh, we didn't check, and you're getting this patent right, but you're getting it with a warning and a disclaimer that it has not been substantively examined. But actually, those things are supposed to be seen as opportunities and avenues for more growth and more development, because it means that the rules are not as rigorous unlike other jurisdictions. So that should be more encouraging to our inventors to come up with these things, come up with these ideas. Okay, any question?
Yes, I was saying, I'm not sure if patent is jurisdictional, because if the rules are not rigorous, if the rules are loose in Nigeria, how about in other jurisdiction where there's actually substantive examinations? Yeah.
Great point. So these IP rights are territorial, right? Patent is territorial, trademark is territorial. Hello, are we good? So I was mentioning that IP rights, yes, they are territorial, right? So they are related to that jurisdiction. So what will apply here, yes, will not apply in a different.
Could have a patent for, say, radio in Nigeria and another person in US for the same product.
That shouldn't be the case, right? Because for a patent to be, that's what I'm trying to distinguish, that examination is not done. We're not checking, or it's not being checked. But generally, it should be checked. That's why they said it's almost like leaving room for people to invent. But you can't say now, because you've given an example of radio or something, or clearly, so all, intents, but everybody knows these things exist. So you can't, that's like copying, basically. You're supposed to be able to think outside the box, but the point being made is that it will be easier for you to obtain a patent. Oh, okay. I'm told to round up. So that was just a point I wanted to break.
One last one.
Okay.
So
right here.
let's say in a case of clear-cut copying, as in the instance of
Mhm.
radio. Considering that patents are jurisdictional, how
Mhm.
does one go about enforcement of your IP, patent IP?
Exactly, because it's territorial, you're not really able to, and that's why, because I work, I deal with a lot of that registration. That people would register. A lot of people are registering their patents in Nigeria because of that copying. It's the same way some people go and make sure they register their things in China so that they have the right to stand in court when issues come up. Right? They
Wow.
are territorial. Unlike, and I know that they are for and that's why there are situations where people would, apply for, regional patents, apply for international patents, and try to get registration in as many countries because of this issue you raised, for enforcement and things like that to be possible. And that's why there's always a plus side, there's a pro and then there's a con to it. There's a benefit to you so that, if you're truly being inventive, if it's obvious, I mean, nobody's talking about going
Yeah.
to copy. Sorry, I want to quickly run through because the other mentors on the call. But so things like plant and animal variety and biological processes are not patentable. I think that there were questions regarding this. So just to hear from the organizers, I want to respond to a question, but I don't know, is that going to come after, or I could just, quickly touch on that?
So we have a question and answer segment, and we'll be treating and
Okay.
talking about questions in that segment.
Exactly. So patents have to be new, haven't been done before, haven't been published before you register. So if you go and you develop something and you start using it or is still in the market, but you don't register it, you can't come back and register unless you published it for, exhibition purpose. Maybe there's this national science fair, and of course you want to win a prize, but there's a timeline in which to do that. So it's always good that once someone, creates or develops, those inventions, those innovations, you come straight to register that patent, because that's where that protection comes in. And in most cases, people may not be, because we're speaking to individuals now. There's a situation of statutory inventor and true inventor speaking to. Most people would pay you and enable you, and equip you, give you the lab to develop what you need to develop. And they're more likely to take on those patent rights. But then you have a right, as an individual to be identified as the true inventor. But because, maybe General Electric or something came and sponsored the lab and gave all, money that enabled it to come to fruition, they might own that patent. Is something to bear in mind. So for things like patent, things like designs, that to enable people achieve, I think that is the collaboration point I want to bring out, to enable you achieve, that goal, which is of course developing that thing. There is room for collaboration, but just to ensure that your own rights are protected, you get what you can out of it. But the success, may be more important, and that should guide the decisions. Because imagine being too stubborn or I want to do this on my own, but you realize you will never have the funds to achieve it just because you want to own the IP. There are different ways to, look at that point. I wanted to bring that out. So for industrial designs, real quick, combinations of lines or, colors, the focus in industrial design on like patents, which is technical, which is looking at, how you're solving a problem. The focus for industrial design is aesthetic, right? So if you develop like we talked about the radio, let's use the radio example, right? But your radio is shaped like a water drop or something like that. It's that shape, that look, what makes it beautiful and attractive is what you are protecting in a design, so that nobody else can come and reproduce it like that. So of course it follows that same newness. It shouldn't have been done before, it shouldn't have been published, before you come and then you register it. And then the timeline for industrial designs is 15 years. After that, for patent is also 20 years. After that, it goes into the public because there's supposed to also be some benefit. And, of course, with time, these things are meant to improve. But in that 15 years or in that 20 years, you are getting your exclusive rights. People are paying for license. Everyone is coming to you. You're making money from your intellectual property. So to quickly wrap up, right, and I've put one or two of that as I was speaking. Always use contracts, creators, inventors, even as you're coming up, try and use contracts. While it's nice to say, oh, that's my friend, that's my family, and the things like that. When things get rough, issues come up. We always hear about musicians, everybody's fighting every day. Something comes up. For musicians, things like a split sheet. Okay, well, I'm writing this verse in your song. This is the percentage. If how many people stream, I want to be getting every 10% from it, things like that. Always, let's have those things written down. It doesn't have to be that you need to get a big shot or top shot lawyer, but, putting pen to paper, the general elements of a contract, having that in place to guide that relationship is good. Always register your IP, particularly key for your patents, your industrial designs, and your trademarks, and also for your copyright, but particularly for those three. Don't work with others unless you have a written contract. That's the collaboration we're speaking about now, because by the time other people are getting involved, things get more complicated. Don't get carried away by the fun of the creative side that you don't know when it's time for the financial or the monetary. There can be issues. Then also be careful what you share. If possible, non-disclosure agreements. If possible, don't even go into, if you're inventing something, don't go into those aspects that are core to the invention, because, like we've talked about it being new, not having access. We've talked about also fixation for copyright. If you go tell someone your lovely idea of your lovely story and it's not fixed, and they go and write it and make it into a movie, and you're like, oh, I told you that day. I'm like, okay, how do you prove it? Just gentleman agreement is your word, and that can get in trouble. So I'll use that to just quickly wrap up. Thank you so much.
Thank you, Ma.
No, amazing. Thank you, Ma.
All right, thank you very much, Ms. Kodechi, for that wonderful presentation. Not to waste any further time, we'll be going on to our next mentor for today, Ms. Amosa Shukurat. Please, Ma, the floor is yours. You have 15 minutes, Ma. Thank you very much.
Hello, everyone. I think the previous speaker has done justice to everything to be said today. I just have few things to say, actually. Can you please share my screen? Do you have it with you, or should I? Okay, I think you're sharing it already.
Yes, Ma, it's up already. Thank you.
All right. So today we are talking about intellectual property for inventors. Last week we talked about IP for business, and today we are looking at inventors, because the IP right for business owners might not be the same IP right for inventors. So you should be able to identify the kind of IP in the business or industry you find yourself in. So as an inventor, what IP rights are you likely, or what IP elements are you likely to see in your business? Next slide, please. So just as brand name and literary work are protected under the umbrella of trademark and copyright, ideas that are applied in useful ways are also protected under patent. And Ms. Kochisi, she has done justice to the topic already, so I won't be taking much of our time, just brief topic one or two, just touch one or two places. The next slide, please. Intellectual property, we all know what it is. It's basically the creation of human mind that is protected from exploitation by third party. And this extends to compensating creatives for their time, money, and creative process put into creative activities. And from what the initial speaker said, she spoke about copyright, trademark, patent, industrial design, and so on and so forth. Next slide, please. And from what we have here, I'll be talking about, should I say, like the life cycle of intellectual property, right? So from this first image, you see that there is an idea in your head. And I believe we all know that idea in itself is not protected as an IP. It is the expression of the idea, or what you have done with that idea, that now leads you to say, okay, maybe you have an IP right that could be a patent, a trademark, a copyright, industrial design, trade secrets, and so on and so forth. So from the first image, you just have the idea in your head. You're not doing anything about it. And the second image, you can see the person is trying to express the idea. Probably are trying to write it out, maybe the chemical formula and all. But there's always that one person that always wants to steal your idea. And this is where protection comes in. So when you are able to protect your rights, then you are able to hold the person by their shoulder, collar, and say, you are infringing on my rights and you need to pay for this or that. So fortunately for this owner of this IP rights, you can see the third image, the person was able to steal the IP right or steal the idea, and they're trying to drag it. Oh, it is mine, it is not yours, it is mine, it is not yours. And at the end of the day, you see that person was able to protect it. And what next? Exchanging this idea to get money. And that's where monetization comes in. So IP should not always stop at protection. Once you are able to identify your IP, the next thing you need to do is protect it. And protecting it now, it could be a registrable right and it could be a non-registrable right. From what our speaker said, you heard that copyrights in most cases are not always registered, because under the copyright law, copyright exists automatically the moment your work is original and fixed. However, for you to prove ownership and all, it's advisable to deposit your work. It's not called registration because copyright doesn't require registration. To deposit your work with the Nigerian Copyright Commission. So just like we have copyrights, which doesn't require registration, we also have trade secrets that doesn't require registration. When we have others that require registration, such as patents, it's a must for you to file a patent application if you want to protect your invention. The same goes with industrial design. It is a must for you to file an industrial design application to protect your industrial design. And when it comes to trademark, yes, if you trademark your brand name earlier or your logo, it gives you upper hand. However, if you're not able to trademark earlier, you can still use the common law under the passing of to fight for your right. But it is important and advisable for you to trademark early so you don't fall victim like we have of very demure, very mindful. Next slide, please. So what are these types of intellectual property? Broadly, IP is divided into two categories. We have the industrial property and we have copyright. So for some of us, you might just be hearing this for the first time. So I'll come again. IP is broadly divided into two. We have industrial property and we have copyrights. And under copyright, we have related rights. So copyright and related rights are on one side and we have industrial property on the other side. So under industrial property, that's where we have trademark, patents, industrial design, trade secrets, GI, TK, and so on and so forth. But our focus will be the ones that we really talk about, which is trademark, industrial design, patents, trade secrets, and the other side of the IP rights, which is copyright and related rights. Mrs. Kodichi has done extensive explanation on copyright and related rights. So I won't be doing much talk on copyright and related rights. So I'll focus more on the industrial property aspects, where we have patents, trademark, industrial design, and maybe trade secrets if time permits. The next slide. Okay, so from what we have here, let me just briefly explain the previous one, please. So you can see that there is padlock around a literary work. Let me say a book. There's padlock around the literary work, and you have the copyright mark on it. That means a literary work like this, they are example of work that are protected by copyright. But it's not just limited to literary work. Like we now know, we have six different categories of work that are protected under copyright, and that's literary work, artistic work, sound recording, musical work, audiovisual work, and broadcast. These are protected under copyright. And the next image, you see something like a C overlapping another C. That's like a channel brand. And since you see that, once you're able to identify this particular logo with channel, then it means that this logo is doing the work of distinguishing and identifying that particular brand in the marketplace. And so it's serving the purpose of a trademark. The next one, we have something like some bolts and nuts and so on and so forth that has to do with patents. Then we have this very beautiful chair whereby you can lie down and still stretch your leg. And that's industrial design. Like we know, it's basically aesthetics. And we have the last one, just telling you to keep quiet about anything that gives you competitive advantage in your business, and that's trade secrets. So the next slide. So patents. So while Ms. Kodichi was presenting, I noticed we had so many questions on patents in the chat box. I might not be able to stay throughout the session, but I'm going to address some of these questions while I'm taking this session. So the next slide. What is patent? So I like to give a very simple definition. Okay, let's look at this. So basic intellectual property tools for inventors. As an inventor, there are some things that you can't run away from. One way or the other, you really might not have copyrights as an element as an inventor. I'm not saying you will not have, but you might not have. But you are very likely to have patents, trademark, and industrial design. Because while your invention is still in the process, you don't have a name for it yet. So let's say if you want to find, let's say you want to do a search on a patent application. If you go and search a patent application and type iPhone, you might not get any application on that, because while that application was being submitted for patent, the brand name has not been discovered, or they've not called it a particular name. So when you are doing a patent search, you want to do a broad search and not the product name, because at that point where the patent application was submitted, they probably might have not come up with the brand name. So patent is that type of IP right that protects inventions that are new, industrially applicable, and inventive. Then trademark now comes later. Okay, fine, we've developed this product or this invention. We now have a minimum viable product. What are we going to call this our MVP? That's where trademark comes in. Then you look at, oh, fine, this trademark is now good for our product. And we want our product to look a particular way that gives it another distinctiveness in the marketplace. What can we do? We are not changing the functionality. We're not changing the name. We just want to give it this aesthetics and, this feeling that when people see it, they like it so much. And that's where industrial design comes in. So this is why I said the basic IP rights for inventors, you look at patent, trademark, and industrial design. The next slide. Okay. Definition on the next slide. Just keep going. So what is patent? I would say that patent, this definition here is the broad definition, but I also give us a simpler definition. So patent is an exclusive right. You should know that all IP rights gives you exclusive rights. It's an exclusive right granted for an invention. Now, this invention, it could be a product like iPhone. It could be a process, kind of a process of making fufu, a process of cooking rice. It could be an equipment to do something that provides a new way of doing something. Now, take note of this. Like I said, the invention could be a product, process, or equipment. Now, what do they do? They provide a new way of doing something, or probably provide solution to a technical problem. So just like we've heard before, your patent has to be solving a problem. If it's not solving a problem, then you might not get patent for it. Next slide. So to the relatable example, I like to call patent a trade by barter. So it's just you saying, oh, government, look, I have this patent that can actually cure a particular solution in my neighborhood, and I want you to help me patent it. And the government said, oh, yes, we can do that for you. And we are going to give you 20 years protection period, such that throughout that 20 years, you have exclusive rights to use the patent, monetize it, do whatever it is you like, license it. But in return, they're going to do one thing for us: disclosure. You're going to give us the disclosure of that patent. Everything about that patent is going to be written in your patent application, and you submit it to the patent office. So when you do that, and we look at your patent, either by the formality examination or substantiveness, if you pass through that process, we are going to give you 20 years protection period. But on one condition, like I said, you give us disclosure to the patent. And they said, okay, fine, that's fine, I'm in. And you do what? You file the application, you make sure the formality examination is done, you put your name, your abstract, your background of the invention, your claim, your drawings, and all, and you disclose it very well. And you file your application. Once it is done, the examination is done, you get your patent grant, and you have 20 years protection period. And once your 20 years expires, what happens? The patent enters the public domain. Now, when it's in the public domain, everybody can now use that patent application to do whatever it is they like. They can work on it, they can update it, and also file an application. But once 20 years expires, your patent is available for everyone to use. And I like to use one particular example. which is the ballpoint pen. So back in the days, I don't know if majority know Big Biro. Big Biro is the name of a ballpoint pen. So in those days, or but let's say during our parents' time, there is no writing material. What they normally use is they dip feather inside ink and they use it to write love letters to our moms and all. But there's always a problem of smearing. If they are traveling, the ink is likely to pour away, or when you close the paper, the ink rubs on each other and what you are writing is not so visible, right? And someone thought, what can we do to solve this problem? Remember, you must be solving a problem. They've identified the problem, and one problem is the ink smearing or the write-up not visible and all. So what can we do to solve this problem? Then two brothers came up and said, okay, fine, let's make something, let's come up with a writing material that can solve this problem. And the both of them came up with the ballpoint pen, and they named it Big Biro because they are two brothers, Big and Biro. So whenever you say, I want to buy Big Biro, just know that's a trademark. And that's one of the trademarks that have become generic over time. So what they did is they found a solution to a problem. And they came up with the Big Biro. At a point, there was Eleganza. Eleganza was selling in the market and people were also buying Eleganza. Then probably Big noticed Eleganza was selling a ballpoint pen using their invention. And probably they had to reach out to Eleganza because at the point we didn't see Eleganza again. My suggestion was, or is that Big reached out to them saying, oh, look, you are infringing on our invention because you don't have rights to manufacture or produce this without our permission. And, before you know it, we didn't see Eleganza again in the market. And Big continued selling using their patents and all. And after 20 years, when the IP right expired, what happened? You need to see the flood of ballpoint pen in the markets. We started seeing Lucky Cora, Cora Lucky, Lucky Cora, Cora Lucky, this, that. But these other ballpoint pen were based on Big's expired patents, right? So once your patent expire, everybody can also use it and they can still work on it, update it, get it to work on it and probably solve another problem and also patent it. And you will see that even Big, that you see these inventors, they don't relax. While it's time for one application to get into the public domain, they find another solution to a problem and they file another patent application. And you will see that there's this Big ballpoint pen that has different color. There's one that has, when you press it, blue, green, yellow, black, white. I don't know if any of you used that particular one. Then there's another one that when you are writing, right on the top, it will be onion light. When you're in school, you're like, I don't see my own pen is writing an onion light. All those things to catch people attention. So these are the kind of additional things they did to their patent to be able to file another application and also make the application work for them. So the next slide, please. So what are the criteria for patentability? Like we all know, it has to be novel. And this is where I'm going to answer the question of, if I file a patent application in the US, can somebody else file in Nigeria? Now, there's something called disclosure, like I said. If you are filing a patent application, one of the requirements is you have to disclose everything about that invention. And now, disclosure is an enemy. Yes, disclosure is an enemy to an invention because disclosure anyway can invalidate your application. And there was a particular scenario of Rihanna posting a footwear of Puma on social media such that footwear invalidated Puma's design patent application. So you have to be very careful when you are disclosing before filing your application. So novelty in patent is absolute. Absolute in the sense that once somebody has disclosed something, even it could be in Nigeria and you are in the US, that Nigerian disclosure will invalidate your application. In fact, up to the extent that publications, journals that are not even patent application, they are also referred to as disclosure. So anything, as long as it has been disclosed, then it can invalidate your patent application. So that's why novelty is very important whenever you are doing all of these things. So the next one is inventiveness. Inventiveness means that is also called non-obviousness. That is, if you put A and B together, I should not easily arrive at C. And this is where they use the term posita. Posita means whatever it is you are doing should not be obvious to a person skilled in the art. So posita is person skilled in the art. So if I put A, or if I put 1 plus 1 together and arrive at 2, that's very obvious to anybody in that art. So inventiveness is that whatever it is you are doing should not be obvious. It has to be inventive. And industrial applicability means that whatever it is you are doing should be something that can be mass produced, that can benefit the masses. So imagine the government gives you 20 years protection period for something that will just be in your room. It doesn't make any sense, right? So these are the criteria for patentability. And the next slide. What can be patented? Like I said, product, process, equipment, and so on and so forth. Then what cannot be patented? I think I saw that in Kodichi's slide. In mathematical method, formulas, plants, animal, bioorganics, and so on and so forth. Things like that cannot be patented, because I think someone asked that question as well. Imagine if there's something that can save your life and someone is holding you ransom because of a patent. So this is why some of these things cannot be patented. Or imagine if someone comes and file a patent application with the title, How to Capture Oxygen in the Air. So imagine someone should do an invention of maybe an equipment that can capture oxygen in the air. Then that means we'll all be fighting for oxygen, right? And we have to even pay to be able to get that oxygen. So these are the reasons why some things cannot be patented. The next slide. So this is a checklist for patent application. Whenever you're filing a patent application, you have to have the title, the abstract. And one thing I didn't mention, which is very important, is a patentable subject matter. The title of your invention has to fall under a patentable subject matter, because even if your invention is new, is industrially applicable, and is inventive, but doesn't fall under the patentable subject matter, you won't be able to file a patent application for it. So the title of your invention has to fall under the patentable subject matter. Then you look at your abstracts, your field of invention, background, drawings, claims, and so on and so forth. The next slide. So types of patents. We don't really call it types of patents, but somehow people have classified it as types of patents, because patent itself deals with the technicality. Why design we call it industrial design here, but people have kind of call it design patent, because that's what they call it in the US, but we call it industrial design here. Industrial design looks at the functionality, not the technicality. So it's possible for you to have a product that has all the elements of IP. Take, for example, our phones. The design of the phone is protected under industrial design. The technicality, how it works, is protected under patent. The name of the brand is trademark. There's 1 or 2 things, maybe the software, the back end, and so on, protected under copyright. Maybe there are some other informations that are not public, that are confidential, protected as trade secrets. So it's possible to have one iron product that has all elements of intellectual property. Next slide. So what's industrial design? Industrial design is the ornamental or aesthetic aspect of the object protected by authorized use. So why do I want to get iPhone 14? Why not just stay with my iPhone 10? Is industrial design. It's just the aesthetics, the ornaments. Oh, I love this car. It has big bum. I love this one. It has small mirror. Oh, this one is very slim and it's big. It's big brother. What do they call those cars? So do you get? Now, if you pick the engine of that big brother and the one of small brother, if you put the one of small brother and big brother, it's likely to work, right? What we are buying is just industrial design, aesthetics, basically. So once you are, as an inventor, you also want to see how people are going to get attracted to your product. And this is where industrial design comes in. You don't want to use the regular design people are using. you want to use something else. Take, for example, there was this particular towel whereby you have to dip it in water, then it's expand, kind of. So that particular design, you can have it sketched out and all, then you have it processed. So things like that are things that can attract people to actually buy your product. Say, for example, when the split AC came out first, initially you think, is this a fridge? Then before you knew it, you say, it's an AC. So in fact, some people would have bought it thinking it was a fridge before they knew it was AC. So things like that also add to your market. The next slide. Industrial design. So these are examples of industrial design. So if you see a bulb that has the first image sign, the second image sign, or the third image sign, which one are you likely to buy? I think I'll go for the third one. I don't know about you. So that's what industrial design is basically. It's just aesthetics. The next slide. So looking at trademark, the previous speaker has done so much on trademarks. Next slide. So trademark is that particular name, slogan, next slide, color, brand name, tagline, phrase, anything that is capable of distinguishing your brand. The previous one, please. The previous one. Yes, it's capable of distinguishing your products from that of your competitors in the market. So something as simple as the Meta logo, when you see it, what comes to your mind is Meta, even though it looks like infinity, but what comes to your mind is Meta, and so on and so forth. The next slide. Now, when you're looking at trademark, people just feel like you can trademark anything. Now, there are criteria whenever you're filing for trademark application. And this boils down to how you want to use your trademark. Also, for business owners who want their business name to be their brand name, you need to look into this concept of the trademark criteria before you actually pick a brand name, because your trademark has to be distinctive. Distinctive in the sense that it is not descriptive, it is not deceptive, it is not generic, and it's not violating public morality. Because if you pick a name, let's say your business name, let's say you sell Apple and your brand name is Apple, does that make any sense? It doesn't make any sense because it's giving out what you are doing. But take a look at a brand name Apple for the tech industry. As in, there's no correlation, right? So that's distinctive in itself. So you want to make sure that your trademark is distinctive in the sense that it is not descriptive. It's not saying shoes by Modupe or something Lagos. You don't want to put all those things. Then it's not deceptive. Don't say you are selling leather, meanwhile you're not selling leather. It should not violate public morality. Don't say your trademark is probably maybe a nude or a person's nude, and you have a Catholic or a imam tesbih or something on it. Things like that doesn't make sense. Then this generic aspect, because even though there are some trademarks that might initially be distinctive, but with time, and because they are not really educating people about this issue of genericness, their trademark eventually gets generic. And getting generic means that your trademark is not identifying you and distinguishing you in the marketplace. Remember that what trademark is meant to do is identify and distinguish. The moment your trademark is not doing that, then it stops becoming a trademark. And probably when it gets to that generic level, it can be taken away from the trademark registry because it has become generic. An example of this, I think we all know that, is Gala, Pampers, Indomie, and so on and so forth. This kind of trademark have become generic because they no longer do their job. If you say you want to buy Pampers, Pampers is a brand name, is not a generic name. But people now take Pampers as a generic name. And when you go there and say you want to buy Pampers, assuming what you want to buy is Huggies, they won't ask you, is it Huggies? Is it Moflix? They'll just give you anything, take and go. And this thing is at the loss of the brand owner, because if you want to buy Huggies, but you go there and say you want to buy Pampers, they'll give you Pampers, not Huggies. So we need to try as much as possible to educate people on genericness. The next slide, let me round up. So what can be trademarked? You have the shape, the name, the symbol, the slogan, color, type, and so on and so forth. All of these things can be trademarked. The next slide. So what are the benefits of trademark? It gives you exclusivity, ownership, monopoly, identify you in the market. It gives you competitive edge and also differentiate your product in the market and so many other things. It attracts investors if you want people to invest. Whenever you want to buy, it gives you value. It adds value to your brand name whenever you want to sell it and so on and so forth. The next one. So these are just guess the brand. When you see this blue, what comes to your mind? When you see this orange interlocking with red, what comes to your mind? When you see this round, blah blah, when you see this lion or trying to leap, what comes to your mind? So if you are able to know these brands by just seeing them, then you should understand the value of trademark. That is, you don't need to know who is behind the company before you can say, oh, this is this, right? So the next.
Hello, Ma. Please, are you still with us? Miss Shukarat, we can't really hear you.
Oh, can you hear me now?
Yes, we can hear you now.
Where did I stop?
On this slide, you were talking about, okay, on the previous slide, you were talking about the identifying the logos of anything without having to know their names.
Okay, so I was saying if you're able to identify this logo, then you are able to understand that when it comes to trademark, people don't really need to see your face. As long as they can understand your brand, they can feel your brand, they know it when they see it. They don't really need to know who is behind the brand. Okay, I think we should love this. The next one is about the period of protection. So we're looking at trademark, like we all know now. Trademark lasts for 7 years initially, then it lasts for 14 years consecutively. Then if you keep using it and keep maintaining it, paying your maintenance fee and all, then you can use it indefinitely. Then for copyright, like I said, copyright lasts throughout the lifetime of the author and 70 years after the death of the author. However, I would like to mention that since we know that there are different categories of work under copyright, some of these categories don't have these throughout the lifetime of the author and 70 years of the death. For example, audiovisual works. Audiovisual works is 50 years from maybe the start of the production date or something like that. So most, like photography as well, is 50 years. Not all of them have this lifetime plus 70 years of the author. I think it's basically musical work, sound recording, and literary work that has this particular lifeline. If I'm wrong, one of the mentors should please address that. Then for patent, like I said, is 20 years. And once you enter the public domain, it's gone. There's no renewing. But what you do majorly for patent is you pay your maintenance fee. And your maintenance fee is on a yearly basis till 20 years protection period. So if you file a patent application now, by the following year, you have to pay your maintenance fee. So every year, you have to pay a yearly maintenance fee till you get to that 20 years, then it goes to the public domain. For industrial design lasts for 5 years initially, then 5 years consecutively. That's 5 years first, another 5 years, another 5 years. So that's 15 years in total. Once that 15 years is over, then your work goes to the public domain. Just like patent, you have to pay maintenance fee for industrial design as well. I think that's the last part of my presentation. And I would like to, the difference. I think we know the difference now. Design is basically aesthetic. It does not protect the functionality. It does not protect the technicality. It's just how it looks, how it feels. Oh, it's beautiful. I love it. That attraction you get once you see a design, that's industrial design. Patent is the technicality, not the, the technicality, how it works, what makes it work, what is the techniques behind this invention. Then trademark, basically identification and distinguishing your brand in the marketplace. So I think that's all from my side. Thank you for listening.
Thank you so much, ma'am.
All right, thank you so much, Ms. Shukurat, for that wonderful breakdown of the topic. So we are going to our next mentor. Can we have Mr. Folarinwa Aluko? Mr. Folarin, are you with us?
Yes, I am. I didn't know
Yes,
I was
sir.
doing that.
Oh, okay.
Yes.
All right.
Hi,
So
good evening.
good evening, sir. We can hear you.
Okay. So I think I have slides. I said some sort of slides. I'll try and speak very quickly to the slides if you don't mind. I trust that I can share my screen. Is that able?
Yes, sir, you can.
Okay. Let me see. Okay. So I must say that all the other presenters have done a fantastic job. And I think that they have actually covered the field. So I'll just try to, speak to some areas that I thought, while thinking about the subject matter, I thought, I'd highlight some issues that may be of interest to creators and inventors. So the first question, when talking about IP for creators and inventors, is who is a creator or an inventor? And I think someone had done a definition from a legal point of view. I have a description here, which is, a general description, how the words are used in the English language. So a creator or inventor is somebody who produces an original content, original ideas, original work. It's a very wide spectrum of platforms. And so this means we heard a lot about creators in the arts and creators in science, tech, even in culture. So you can have creators in culture. So the term actually is, both terms can be used interchangeably, creator and inventor. Although technically speaking, from a legal point of view, when talking about inventors, you tend to refer to patentees or persons who apply for a patent. But that ground, so much ground has been covered in that area already. So you have, like I said, different types of persons and categories that fall under the description or definition of creator / inventor from a general point of view, an English language perspective. I have an interesting thought. There was something that people that used to do back in the day. She used to, I think back in the day, like, I think I saw some of her content. She does some translations to Yoruba. So I like to think, I think in Yoruba.
That's hard work.
I think it is very hard work. So I ask myself, what is the definition, or what is the creator or inventor in Yoruba? And Shukra is here; she can help us. I'm sure she's done a lot of that. So in terms of the category of who qualify as an inventor or creator, you have artists, writers. I mean, there's a list on the screen. I won't trouble us with that. But very importantly, I think it also includes digital content creators. And the reason why I want to highlight that is because, what we call intellectual property. I mean, when the Anglo-Saxons trace the origin of the first IP law, they go back to the Statute of Anne. I like to highlight the fact that that statute or that law sought to create a monopoly for literary works, particularly print. But the scope of works that are protected by intellectual property laws has expanded, and particularly with regards to copyright, it has expanded beyond that one to a very wide range, to about 8 under our current law. And anyway, that's a different conversation. But so the idea is that forms of expression are actually infinite, and I'll explain why that is important. Because forms of expression are infinite, and so with new technology, we tend to see newer forms of expression. So this is IP, the idea or concept of IP is still an ongoing conversation. And the idea of the concept of, the property itself that we refer to as intellectual property is much wider than the range of rights that exist to protect these works. So generally speaking, intellectual property is property, and I thought a lot about the phrase intellectual property and what it actually means. If you think about it, why do you have to put intellectual in front of the property? But before we start talking about what type of property is intellectual and what type is not, what type is not intellectual, the general presumption is that IP is property. So if it is property, then where do we then derive the right to own property from? And in Nigeria, so I won't take us too much into the conversation about the right to own property and all that, but in Nigeria, our constitution, section 44 of our constitution, provides for the right to own. It's not even the right to own, it actually provides for the right to compensation in the event of the compulsory acquisition of movable property. And I find that very interesting, that section, which we tend to refer to as the right to own property, is actually, it actually distinguishes between, or it identifies a particular type of property, and it talks about movable property or interest in immovable property. So I find that to be very interesting, because in law, one of the maxims of interpretation is that when you mention something expressly, you automatically exclude every other thing that is not expressed. So expresso unius full of interpretation. And if you were to look through the other sections, so section 43, 44, other sections of the Constitution relating to the right to own property, you find that the Constitution doesn't make a positive statement about the right to own property. I think that is, whether tangible or intangible, I think that is a bit of an oversight, but generally speaking, since we already acknowledge that our Constitution contains a right to interest in, to protection from the compulsory acquisition of movable or immovable property, what will we define as tangible or movable property? That will include land, improvements on land, buildings, things like that, machinery. Things that we can talk physically, that's about monthly research program, relationships, supply, distribution, distributor relationships, and things like that. Of course, trademark patents, and so on and so forth. Now, interestingly, Article 14 of the African Charter on Human and People's Rights actually guarantees the right to property. So there's a positive right to own property that is provided for under the African Charter of Human and People's Rights. And I think what this does, because we've been fortunate enough to have litigation up to the Supreme Court. I think Attorney General of Ondo, then AG Federation, and 36 others, 35 others, I think, tells us that the African Charter stands in the same position as the Constitution, when with regards to the protection of fundamental rights. And this includes the right to own property. So IP is property, and we should think of it as property that belongs to someone. So because it is property that has a legal life and an economic life. So when talking about the legal nature, the legal life of intellectual property, it's important to highlight that when we use the term IP, I said earlier that intellectual property, the range of works of property is almost infinite, but there's a finite range of rights that protect this infinite, range of works, if you mean. So the term IP itself is very different and distinct from the legal framework that exist to protect that property. So when you're talking about intellectual property, you're speaking about the thing itself, the expressed idea. But when we talk about intellectual property rights, we're referring to the legal framework or the machinery used to protect that intellectual property. So, and a good example of this would be Chinua Achebe's Things Fall Apart. So the book itself is the intellectual property, the work. But the work is protected by copyright. So there's copyright in the book. And that copyright is the legal regime that protects that work. So this is important when deconstructing what a creator owns. When they say, oh, I have intellectual property or have a right to this intellectual property. And so intellectual property rights are created either by statute, I think we had covered this previously, by statute or by common law or by customary usage. And this is because rights don't exist in a vacuum. So the rights must be provided for by something. There must be something that you derive the existence of those rights from. So these rights, we've talked a lot about the trademarks, copyrights, patents, and so on and so forth. The law allows the IP owner to deal with, so the creator and inventor can deal with these rights either singularly as a bundle, or the person can unbundle the different rights. So for example, copyright comes as one, we refer to it as copyright, but it includes the right to control the translation of the work. It includes the right to control the distribution of the work. It includes the right to copy, which is the fundamental basis for copyright. The owner can deal with all these rights as a composite, can unbundle them and license them or deal with them individually. There's an interesting conversation that I'm having with a client about the ways in which he entered into a distribution agreement about 15 years ago, and that distribution agreement was as explicit as it could have been in those days, but it didn't capture streaming revenue or on streaming platforms. So there's a whole, we're now talking about how to exploit that unexploited right. So talking about that's so much about the legal aspect of intellectual property, right? So the legal nature of IP. Now, IP is economic because it is property. And if we look at, I have a chart here that if you chart, there's a lot of money on the table. And it's like a list of top brands, the industries, and the value of those brands. So IP is economic. And one of the reasons why it is very important is because it is property that has value. And that value is intrinsic, as in the value, we have its value by virtue of creation. We have its value as a function of the importance that we attach to that IP, or it may have its value as a function of what the market says its value is. But the bottom line is that it has value. And that economic nature makes intellectual property an asset. So IP assets are intangible in that they are protected by the law that can be enforced against third parties. And these assets are identifiable, they are transferable, and they have an economic lifespan that is distinct and separate from their legal lifespan. Of course, an asset is something that can be controlled by an entity as a result of past events. So a resource that can be controlled by an entity, this may be an individual, a company, or a business. This resource must come to the resource. The resource is the result of a past event. So that past event may be the purchase, so you can purchase intellectual property. It may be creation. A songwriter can write a song, but there must be a past event that gives rise or gives birth to that resource. And this capable of providing future economic benefits, the ability to reduce the cost of production or the cost of operation. I'll just try and run through this. So we'll look very quickly at the very prolific creator, king of pop, Michael Jackson, and components of the IP portfolio in his estate. A lot, funny enough, I guess that we probably talk about lifespan of intellectual property rights, and I think all our previous mentors have said quite a lot about the lifespan. So let me just demonstrate that very quickly. So some key points. So Michael Jackson is no longer not alive anymore, but his estate has the intellectual property in his estate has been organized into different portfolios. So some of the components of his estate portfolio include the musical copyright, that portfolio, which of course includes the extensive catalog of music, including hit singles, albums, and unreleased tracks. I should mention that Michael Jackson was always working. I read the book, an autobiography recently. I forget the name now. Forgive me, but a producer that I have an interest in, a hip hop producer, was stating that he actually did a lot of work. He did some tracks, about 4 or 5 tracks with Michael Jackson. He produced some tracks with Michael Jackson, and he said that those tracks are unreleased. So it struck me that you have Michael Jackson, for example. Many artists tend to have several unreleased tracks. There's this popular skit of Dave Chappelle skit about Tupac and how Tupac was rapping from beyond the grave. But these people have works that are unreleased, and so his estate consists of the hit singles, his albums, unreleased tracks, which I think he has had, I don't know how many posthumous albums the MJ estate has released, but he has released posthumous albums. So the estate manages the rights to this music, licensing, and so on and so forth. MJ also owns the rights to several master recordings, so his own master recording and the master recordings of other artists. I think very famously the Beatles and the Elvis Presley masters. The estate owns the name and likeness, Michael Jackson, and there's a concept in I'm not sure if it's a Disney concept, but there's a concept in the US that uses or utilizes Michael Jackson's image. So there's a holographic representation of MJ that performs as that concept. So of course, in order to protect that, that performance or that idea, it involves a very wide range of registrations from, the trademark, the image, the likeness, and so on and so forth. Then, of course, you also have the merchandising of his image for collectibles, for products, and things like that, and the use of his audiovisual works in films and documentaries. And of course, I was reading, I think it was an interview by Quincy Jones some months ago, and he was talking about the original artwork for the Thriller album. The Thriller album was like multiple platinum when it was released. It was the album that really defined the persona of Michael Jackson as a solo artist. And he was talking about how that artwork was auctioned for some undisclosed amount. So the estate actually holds visual art and artistic works, as part of his portfolio. I had mentioned earlier that Michael Jackson holds master recordings, so he holds publishing rights to several master recordings. So I think, in a nutshell, I tried to just highlight in a very practical way the nature of intellectual property and how, let me stop the share, okay, the nature of intellectual property and how its legal and economic life affect creators and inventors. So thank you very, very much.
Thank you so much, Mr. Folarin, for that wonderful presentation. Please, can we have Mr. Max come there? So if you're still with us, we'll just like for you to come and just quickly give us more insights on the topic for today.
Okay, thank you. Can you hear me?
Yes, sir, we can hear you, sir.
Okay, thank you very much. Our time is fast spent. I'm also anxious to hear the mentees. So I'll really keep my comments brief, and also just to acknowledge all the mentors who have gone before me. I think, with all that the mentors have done, even myself who joined this session as a mentor, I think I'm entitled to get a diploma because the learning has really been intense. I think all the mentees should really count yourselves fortunate to have attended this session today. So having said that, I would say just two things. I hope to keep it in under 2 minutes so we can quickly proceed. So the other mentors have said a lot of things. I just want to give some practical advice, particularly for you as an IP consultant to creatives and inventors. With creative and inventors, more often than not, the people they might come to, particularly for creatives, a lot of them are not yet very sophisticated. There would likely be the kinds of market you can easily get because they are not, particularly when they have not blown yet. Use that word. I just noticed today that the guy from, I believe is it Botswana, who won the 200-meter race at the Olympics, that a very big law firm, DLA Piper, has just signed some sort of agreement with him. So you can imagine that, because he's gotten to that point, the big guys will get him. But for you now at this stage, you can actually reach out to, the creatives who are not yet blown, the guys who are still trying to do something on Instagram, on YouTube, and other channels, and hope to become their consultant. So that's just a practical tip that, IP for creatives is something that is really relevant to you. What are some of the things you need to do for them? A lot of it would be advisory, a lot of what has been said. One of the tricks, for instance, for creatives that they should notice this is that, writing from what the other mentors have said, for artistic, literary, and musical works, the length of copyright duration is 70 years from the death of the author, if the copyright is held in the name of the author of the work and not the name of his company. So that is a simple advice. And this actually applies a lot to tech startups, that when you don't have to register your copyright, but in designing your program to your internal processes in your company to capture who is the creator of a work of copyright, you should always name the individual and let that individual do an assignment of the copyright to the company, so that way the company or that work of copyright still gets the benefit of the full length of the lifetime of the author and 7 years after, unlike copyright that is gotten in the name of the company or is stated to have been created by a corporate entity that would last only for 50 years. Then another practical point to also note is that you might also be engaged as a consultant, maybe to do due diligence for a startup trying to seek early stage funding. One of the key things to note is that anybody who's going to fund a startup wants to be 100% sure that all IP, that startup is using, even though created by the founders, has been properly transferred to the company. That's to avoid a situation where the founder leaves the company and then there's a challenge with the company still having a right to utilize those IP rights. So sometimes it's as simple as even in co-founders agreement. You're advising co-founders, ensure they put it there clearly in the agreement that all IP developed individually by them pre the establishment of the business, but don't use for the business, should, in consideration for whatever they are getting in terms of equity, should transfer that those intellectual property works to the company. Like I said, these are simple things that could become troublesome when there's a fallout between co-founders. So these are just little tips I wanted to give to help you, guide you if you find yourself advising startups. So I'll end at that. Thank you.
Okay, thank you very much, sir. Thank you so much for that wonderful practical example you gave to help our mentees just better gain an understanding of today's topic. So not to waste any time, we are almost spent on time, right? So please, we would just like to take presentations quickly. Group 3 and 4, right? So in the IP class, we have 4 groups. Group 1 and 2 had their presentation last week.
Can I just say a point?
Okay, Miss Regina, yes. Okay, sorry, I did not know you were still with us. So please, ma, the floor is yours. You can just quickly share what you have with us, ma. Thank you.
Okay, thank you very much. It's been raining here in Abuja, so the network has really been bad. All the mentors have really extensively talked to the point, but I just wanted to mention a point. I have so many highlighted, but they've all been dealt with. The facts about the newness requirement for patent. So yes, it's important that the patent is new, but it's important to also highlight that the patent or the invention should not form part of the state of the art, and that is as provided in the law. And to mention, I think Shukura mentioned it, that the requirement here is a universal standard. That is that the patent should not have been published anywhere in the world, but there are some exceptions to that rule. So if that patent has been published within 6 months in any official exhibition before the application to register the invention, that could be excused. And if the publication was made in a confidential manner, if there is a confidential relationship like a boss and an employer-employee relationship, so if there is any confidential relation, the publication could be excused. I thought to mention that. Thank you very much.
Thank you so much, Ms. Regina, for stepping in to make that point. We really, really do appreciate. Sorry for skipping you out. It was not intentional. I thought you were no longer on the call. So like I was saying earlier, please, can we have group 3 and group 4 presenters just prepare for your presentation? Group 3, please, you have 5 minutes for your presentation. Try as much as possible to stick to time so that we can move on to questions and answers. So please, if the group 3 presenter is ready, please go ahead, share your screen and start your presentation. Do we have the group 3 presenter or the backup presenter in class? If group 3 is not ready, please, can we have group 4 instead? Please, let's not waste any time. We are already fast spent on time. Can we have group 4? Presenter, backup presenter, or any member generally from the group. You can go ahead, share your screen and start your presentation. Okay, please, can we indicate, please, if you're a member of group 4, please indicate yourself. If you're a member of group 4 or group 3, please indicate. Please, we want to know if there are members of that group on this call. All right. I can see one person indicating. Susanna, all right, please, on behalf of your group, can you kindly make the presentation? If there's the need, I will do well to share screen on behalf of the group.
Hi, good evening.
Yes, good evening. Okay, good evening, Mercy.
Yes. Please. Is it possible for me to share my screen?
Yes, it is. Please go ahead and share your screen.
All right.
You are presenting on which group's behalf?
On behalf of group 3.
All right, thank you, Mercy.
All right.
So while Mercy is trying to share her screen, please let group 4 put themselves together and also get ready to present. Remember, presentation is for 5 minutes. Thank you as you comply.
Okay, can you see my screen?
Yes, we can see your screen.
Yes, we can.
All right. Okay, so our topic is intellectual property for creatives and innovations. Innovators rather. We're looking at literary works, visual arts, dance, film, music, software programs, fashion, broadcast, and comedy. So we gave a brief definition of what a literary work is, and we said that it's any work other than audio visual works which is expressed in numbers, words, or verbal numerical symbols. And so the type of intellectual property for literary works would be copyright. It connotes, writings and all of that, all other literary text, like textbooks and all of that. So the conditions must be, it must be original, it must be expressed and fixed in a permanent material form. The author must satisfy the requirements in the Copyright Act of 2022 in order to be qualified. And there must be originality in the sense that it must be your own, it must be unique in a way, right? It must be your own thoughts that are expressed in writings. And it's the copyright protection lasts during the lifetime of an author. That's with an addition of 70 years after the author's death. So that we don't waste much time. So we have intellectual property for visual arts. Visual arts is any creative art, like one of our mentors had already shared and gave an illustration on a painting, right? So that is part of artistic work. So it also falls under copyright. And you have paintings, drawings, carvings, sculptures, photography, and architecture. The ownership of basically what you enjoy is like ownership of the physical property right of the artwork. Like for instance, you have Nike Art Gallery. Most of her paintings will fall into this category because she is the direct owner of the physical paint or artwork. Or for instance, maybe she gets to maybe buy, or someone comes to her gallery to market their own this thing, they will have their ownership while she has some rights. So we have intellectual property for dance. That's the rhythmical movement of the body to sound and music. One of our mentors already explained about the performance rights, right? So for instance, someone is paid to dance up on a stage. Most of those movements would like be specific or be unique to that particular person. Like we have dance steps like shoki, skelewu, and all of that. So we all know like those are that falls under dance, and then it's also part of copyright. And then the requirements, it must be fixed, it should be recorded or written in a tangible form. The choreographer must also satisfy personal requirements so that the dance can be protected. And we've enumerated how to make your dance fixed. That's video recording, performance, photograph, drawings, textual descriptions, and the copyright of the dance is basically owned by the choreographer. You have numerous choreographers that you can think of when your mind goes there. Then we have film. That's It's the fixation of a sequence of visual images capable of being the subject of a reproduction. And I don't know if we should go
Mercy, can you hear us? Your network seems to be shaking.
Copyright and can you hear me?
Yes, we can hear you now.
Okay, sorry for that. So where did you stop with me?
Just on intellectual property for film, you were talking about it.
Okay, yes, intellectual property for film. I was saying that the copyright protection for films lasts 70 years after publication. That's section 17 sub 1 of the Copyright Act, and it's more like a legacy sort of, but you still have control like over your work and all of that. And then we have music. A musical work is defined as any musical composition, irrespective of musical quality, and includes work composed for musical accompaniment. It will also be under copyright, and we have a case, Hyperion Records Limited versus Dr. Lionel Shawkins. Because of time, I'm just trying to move really fast because most of these things have already been discussed. When can copyright infringement in musical work be said to have occurred? That's when someone uses another person's creative work without their permission. To give more context to that, there are sometimes where maybe you can use a beat from let's say Davido Wizkid song, and you didn't seek permission before using that. That would be termed as copyright. So sorry, just trying to move fast. Software programs, with legal protection for code meant to be read by machine. You have codes, you have people that build websites, they deal with a lot of codes and all of that. So we have to also know that a programmer automatically owns, and it lasts 70 years after the death of the programmer. That's people that deal with programming and all of that. However, it's necessary to enforce legal rights on the developed program and to enforce copyright and prevent unauthorized copying and use of your software application. Software IP protection strategy must be
Sorry, Mercy, we can't really hear you anymore. And please, can you try to round up your
and
presentation?
you can only do this by you can only do this by making your software. Hello.
Yes, we can hear you now.
Hello.
Please, can you
Okay.
speed up your presentation if
All
that's
right.
possible?
So there's fashion. We have copyright as well. They also make use of trademarks and trade secrets. Then there's industrial IP protection. We have the enforcement of that. There's broadcast, trademarks, database rights, trade secrets, and what have you. I still have a lot of slides to go. Please, is it possible we share this on the group since there's no much time?
Yes, you can.
All right, thank you.
All right, thank you, Messi. Sorry we had to give you little time to make your presentation. This is because we are far spent on time. At least we've gotten the opportunity to listen to our mentors. So we just want the opportunity to hear from both groups, and then we'll take questions because we expect that over the course of the research, there are particular issues that you may have raised. So while presenting, the mentors can also gauge and see your knowledge gap, and they can make reference to some of the things you may have missed in the presentation. So thank you so much, Messi. I'll do for stepping in on behalf of your group to make your presentation. Please, can we have group 4? If it's possible, group 4, can you take your presentation now? Try and stick to time, 5 minutes, so that we can go to questions and answers. Do we have the presenter for group 4 ready? All right, thank you, Susanna. Please, you can go ahead and continue your presentation.
So, all right, sir, I will be presenting on behalf of Group 4 in the absence of the presenters, sir.
All right, thank you.
All right, so presentation centers on intellectual property for inventors. So we are going to be highlighting some key issues so relating to intellectual property for inventors. So we can move the slide, please. So intellectual property, as has been explained by many of our mentors, so has to do with creation of minds, and they can be legally protected. So in the industry, I mean, for inventors generally, so we have different intellectual property that they can protect. So as explained by majority of our mentors, that intellectual property elements cut across in any invention. So we have different elements of intellectual property. So we have the trademark, we have patents, we have industrial design, and we have copyrights. Now we look at the importance of IP for inventors. So it is very important because it generates revenue for inventors. Another one is recognition. So they also gain recognition through their intellectual property because it's an invaluable, intangible asset for inventors. So it allows them to gain recognition, and it also gives them competitive edge so in the market space. So we look at types of intellectual property. So it's actually related to intellectual property for inventors. So as has been explained, so that we have patents. Most especially the most common intellectual property for inventors are patents, trademarks, copyright, trade secrets. So emphasis on trade secret for inventors. The next one, please. So IP can be used in the ICT industry. So considering the robust nature of our presentation, so we'll be looking at IP for inventors in different industries. So we are looking at ICT industry. So in the information in the ICT industry, so we have different intellectual properties that are inherent in the assets. So we have trademarks, we have trade secrets, we have copywriting, we have patents. So examples of telecommunication companies that achieve substantial market share through the protection of their trademark brand. So as I've said, that one of the elements that are common in the ICT industry, so it's a trademark. We look at BlackBerry versus type of products. So these are typical example of ICT. So that was able to protect its intellectual property through trademarks. So let's move to the next one, please. So we have different examples. So in the ICT industry, so where intellectual property is protected. So through different elements of intellectual property or through different subject matter of intellectual property, trademarks, trade secrets, and patents, industrial designs. So a company that faces legal challenge, so due to copyright infringement in communication industry. So as we all know, that there are situations whereby some industries will face challenges due to the fact that they are unable to protect their intellectual property. So this points to the fact that protection of intellectual property in any industry is very crucial, so as to ensure that no other party is infringing on their on their assets. So I mean intangible assets in the industry. So we'll move to the next one for the sake of time. So how can inventors in tech space use IP? So as I've said in our presentation, that intellectual property for protection is crucial in the tech industry. So as to safeguard innovative creations like software. So most of the elements of intellectual property that are common in the tech industry. So we look at an instance like software algorithms and user interface. So these elements are very essential for protection, most especially under copyright or any other subject matter or of intellectual property. So it is very essential and crucial for inventors in the tech industry to safeguard this, because that's where the strength lies. So in the tech industry, so and it can be protected in many ways: trademark, patents, data rights, confidentiality. Is most especially protected in on trade secrets. So and it's very crucial in the tech industry. So let's move to the next one, please. So we have instances of tech startups who were able to successfully use copyright protection to safeguard the software protection. So we have an instance of MDY Industries LLC versus Blizzard Entertainment. So this is a typical example of a tech industry that was able to successfully protect its software against infringement from a third party. So another instance given here is the music industry versus NAFTA. So these are typical examples of industries that are able to protect the intellectual property assets against infringement from a third party. The next one. So we have different examples: Apple versus Samsung. So this has to do with the tech industry that face serious challenges when it comes to, in the case of copyright infringement. So due to the fact that the protection was not properly made, so and it caused the different challenges. So one of the challenges, which was not actually the making of the industry, is territorial issue. So it has to do with one of the challenges we have in the legal space. So we'll move to the next one. So we have another one. So the use of IP in engineering industry. So as I said, that we have robust discussions to make as far as our presentation is concerned. So we'll move to another industry. So in the engineering industry, intellectual property plays a critical role in safeguarding innovative technologies. So intellectual property protection is very essential in the in this industry also, most especially when it comes to innovating technologies like machines and the like. So they can be best protected under patents and industrial design and trade secrets. So I will be giving an example of solar forced solar. So as a leading example of how patent protection can drive substantial business success in engineering industry. So let's move to the next one, please. So this another example, A12030 systems. So it's also one of the examples of how important protection of intellectual property is in the engineering industry. Yeah, the next one. So we have another invention. So that has to do with pharmaceutical industry. It's also one of the important industries that need to protect their intellectual property assets. So they can be protected, as mentioned by some of our mentors, that they can protect their intellectual property under industrial trademark and patents, so and some other domains of intellectual property. So for every industry, it is very important they guard the intellectual property against infringement so as to maintain competitive edge in the market space. Let's move on.
All right, Mr. Ridwan, please, can you try to round up if that's possible?
Okay, no problem. Thank you. So it's just because of the limited time we have, and we have robust discussions on our presentation. So please, for the sake of conclusion, so we'll go to the benefits of IP protection event. So one of the benefits, so we have exclusive right. It gives exclusive rights to the industries who are able to protect their intellectual property. They gain monetary benefits, where they gain recognition, competitive advantage, incentives, innovation. So prevents misappropriation. So the products or the inventions will be attributed to them. We have global protection and all others. So seeking advice from IP attorneys. So these are the strategies the inventors can take in order to safeguard the intellectual property, so as to get the benefits we earlier mentioned. So the trend, so that may occur in the future. So what we have foreseen in our presentation. So thank you very much for having us.
All right, thank you so much, Mr. Ridwan, and thank you, Susanna, for sharing the slides on behalf of your group. I'm sorry we spent so much time in this particular class. We just had to cover based off of what we had. So before we head on to the question and answer session, Ms. Onyekachi has been on the call. I was not in the know of that. So my kind apologies, Ma. So please, Ma, if it's possible, we just want to quickly hear from you what you have for us today quickly, so that we can go to the question and answer. Thank you very much, Ma.
Hello, good evening, everyone. Thank you for
Yes, good
having
evening,
me.
Ma.
If I'm able to share my slides, I'll quickly put up something and then speak to a few of the pages, because of the slides, a lot has been said already that tells essentially what everyone has said already. IP remains, how do I put it? It's a subject line. So there's no how you have too many experts on the call and the same information is not repeated again and again. And I've made my suggestion, which I hope Jiipcc will do something about, to streamline each topic, break it down according to the number of experts you have on the call. So everybody takes a particular aspect so that you don't have too many repetitions. So, but I'll just go straight to one or two things I feel were not mentioned. I've been on the call for close to 2 hours. I think I listened through. So on this slide now, it talks about, let me use my slide. I'm sure you can see me. All right, so this is on division of IP rights. I heard one of the experts talk about, meanwhile, thank you to all the experts. A lot has been said, I appreciate, and you've also made my work to be easy. So thank you so much, and I hope the mentees have been learning a lot. You're so lucky, your set is so lucky. We've never had it like this on Jiipcc, that's the honest truth. So on divisions of intellectual property rights, you've learned about the division of IP. It's segmented into copyrights and related rights, and then you also have industrial property, where you have your trademark, your patents, and industrial designs. So now, but there's different from that is division of intellectual property rights, which is basically the personal rights and communal rights. So on the personal rights, it's where you have those industrial property, your trademarks or patents, your industrial design, and also the copyrights. However, communal ownership of rights essentially has to do with GIs, genetic resources, traditional knowledge, and traditional cultural expression, amongst others. I won't discuss again what patent is. It's been mentioned severally. So I'll just run through. So looking at the patent litmus test, that's what I choose to call it. Essentially, we'll be looking at what amounts to novelty. I work in the office. So what would I look out for if I say patent application? So the question, is it new? Whether it's in a different jurisdiction or within Nigeria, I want to check if it's somewhere, maybe online, maybe in any material form. Somebody has talked about it on radio, any means at all. Is it existing somewhere? It can also exist in people's tradition and culture. Like you have the turmeric case that is relevant to Indians and in the US, whereby somebody went to the US to register that, and then Indians had to bring an opposition. And then they were able to make sure that the patent was not granted. So these are some of the things to look out for. However, there are two schools of thought on novelty, especially as it benefits Africans, because the last few months, I think I've been impacted enough to want to discuss what benefits Africa as against what we see in literature and what the white man wants us to run with. I believe Jiipcc is for Africans, so let's do it the African way. Novelty in some climes is now being reduced to want to now mean, is it novel within your jurisdiction? Or should we broadly extend it to cover novelty with regards to what has been registered in the US, in the UK, and what have you? For example, in Ethiopia, you have what they call patent by introduction. That's the first to introduce a patent, which means an Ethiopian can go to the US, carry a patent from there, and is the first to introduce it in Ethiopia. Once that is done, such a person is granted a patent in Ethiopia. Not so many African countries will want to do this. Some will want to dance to the books because they're registered or members of one treaty or the other. So we are bound by it. The good thing is this: Nigeria may be signatory, but most of these treaties, they are yet to be domesticated because we operate a dual system. So which means Nigeria, like other African countries, can also benefit from this and think about what will grow our economy. This is one of the things that can grow our economy. I'm also one of those who believe that the inventive step is too high. We need to reduce it. What are the inventive steps? These are steps that shows the materials or the products or the connectivity, everything workable put together to generate a patent. It can be like the materials, say, if it's medicine, you begin to talk about what maybe chemical compositions were put together to arrive at the medicine. So we begin to streamline it such that even if it's already existing somewhere already, we bring it down. We don't have to be so high up there. So what we use in the office currently is quite high, knocking off most Nigerian patents, and it's a pity. Let me run through something else. I know they've talked about disclosure extensively, so I wouldn't discuss on disclosure again. However, I have a caveat. When we talk about disclosure, we see a lot of people on social media. You think you have arrived at something and then you want to run with it. You go on social media to say, oh, I was able to build a car, I was able to do this, do a generator that runs on water and what have you. You have disclosed already. The only exception by the act is such that was disclosed during a science fair, and you have within 6 months to register. And I know one of the mentors had mentioned this as well. So that is a caveat you must have in mind, and it's the reason why you and I, after today, need to go back to our closed door community and discuss some of these things so that people don't just run out on the social media so they start dancing about what they have created until at least they have registered a patent. Or if there's something you can keep secret, like a trade secret, why not? However, on trade secret, if it's something that has to do with electronics, a tangible good like a product, and you know it can be reverse engineered, so you shouldn't be thinking about trade secret. Because if you do trade secret and somebody can actually carry your gadgets and uncouple it and then couple it back, creating their own, then you don't have a trade secret again. Your secret is now in the open and you can't sue the other party. So if it's something tangible, think patent. If it's something that has to do with maybe materials or substance or method of cooking something or method of doing something like recipes, why not? Think trade secret. This is a brain teaser, but there's no time for it. Now, who can file? This is a group of persons we expect to be able to file either a patent or even industrial design. Now I'm going to start marrying both of them together. Maybe an employer, a PCT state. These are patent cooperative treaty states. Foreigners who are not member of the PCT state can also file a patent. Then the Act differentiates between true inventor and statutory inventor under patent. Who is a true inventor? This is the original person, or as many people that came together to think about that patent, to think about that creation, to think about that invention and put it down. Either the person was able to say, okay, let's do this area like this, the A to B of it. Another person was able to do the C to D of it. Another person, maybe they created the car refused to run. Somebody just comes from nowhere and said, oh, why don't you connect this wire and add it to this place? And that's just it. That little statement, that person definitely should be mentioned as a true inventor. Remember, failure to mention a true inventor in a patent application can lead to such a patent application for someone to apply to say that, okay, I wasn't mentioned. And then such an application is going to either refused, depending on if it hasn't been granted already, or if it has been granted, they can say, okay, let's withdraw this patent application. So it's a very germane information. So I thought to also mention that. Is it easy to draft a patent application? Far from easy. So these are the reasons why awareness creation of this platform is very germane. This is one of the reasons why the patent office, we don't have too many local patents filed at the office because we have less experts in this area. So if from this program, I don't know if they're discussing patent drafting at some point, you're able to gain that information or expertise, you're expected to also go back to your community, help your neighbors, help them work their patent application. It's not an easy task. That's one thing I should let you know. So what do you expect to see in a patent application? Apart from applicant details, I know they've said some things about this. These are the things in this order we expect to see in the patent document: the title of invention, the technical field of invention, the title, not necessarily like your trademark title. It has to be a title that from the title, people can tell this is what your invention is all about. Maybe a method of cooking tea, or maybe something that has to do with a device. So the title should let people connect with what your invention is all about. This is because I can go on the internet to say I'm looking for inventions on a particular field. Through the title, by the time I look for synonyms that has to do with that particular invention, yours should be able to pop up as well. So if you just use anyhow title, you've lost out. Now, what is the technical field of invention? Not more than 2 lines. Now you begin to say, okay, this patent invention has to do with maybe engineering field, particularly maybe the method of maybe adding fuel in a car. That's an engineering field, but particularly to a particular thing. Now, what is the background? What is in the prior arts? Is it existing before? Yes, you're not the first to create a car. Somebody else has created a car. So you need to mention that. The progresses that have been noticed in the prior arts. What stage of invention are you? What stage are you? What is that new thing? Or what is the gap you are trying to bridge? Don't forget, a patent can be over something that is new entirely, or an improvement on what had been existing before. So in a situation that it is a car had been existing. So yours is an improvement. So maybe there's something you are bringing to the engine of the car that will make the engine not just to run on water, to run on maybe gas, or even to run on charcoal. And nobody has heard of this. It's like an incremental value that you are bringing on the table. And such will be granted a patent. The statement of the invention. Here you begin to state, these are the gaps I noticed in the prior art. And then your object of information is then saying, this is what I am bringing on the table to cure the gaps in the prior art. Then the summary of the invention is about the totality of everything about your invention. If you have tables to show, if it's a method, most likely it's going to be a table. If it's a product, then we want to see pictures, or rather drawings. Then detailed description of the drawing to then say, drawing A is this, drawing B is this. Detailed description of the invention is also required. Then you talk about the claims. I know what is said about claims, that a claim that is not claimed is deemed unclaimed. So if you created something, or if you invented something and you forgot to mention an aspect of it, and it is registered as a patent is granted. If B comes tomorrow, makes an improvement on what you had earlier created, and makes mention of that aspect you failed to claim, there's nothing you and I can do about it. Then the last would be your abstract. This is also a brain teaser. We'll leave it. I limited my slide to patents and industrial design. I know a lot has been said of industrial design, so I'll just use this picture to explain to me what it means. This is a plain school bag, and this is a bag with character. If you took a 3-5 years old child to the market, now it's back to school season, which bag do you think the child will pick? Without us thinking twice, you know it's a character bag. That is all what industrial design is all about. Whereas patent speaks to the engine or the technicalities of the invention or the engineering behind the working of a thing, such as a fan. Industrial design talks about the aesthetics. That is the outer parts of the fan, like the color of the fan, the height of the fan, the shape of the blade, and what have you. These are the classification of industrial design, broadly classified in two. You have textile design that has to do with materials, either made or made, like school uniforms, like all these traditional clothes by different tribes in Nigeria, they're all registered. Then you have the non-textile design that has to do with products. Then how many years does it run? They've said it, 15 years as a whole. The first 5 years, then you renew for another 5 years and another 5 years. So what happens at the end of these 15 years? What most companies do, like I use example of some products in the market. You see a particular product, let's use Indomie. Before you know it, Indomie will come back tomorrow and say they have on-demand size, or they have this particular one. That's what they're trying to do is, a particular one is about to elapse. And so in order for it not to just go away from the market like that, because any other person can make that particular size, they extend it and make something else and name it something else, different from just Indomie, because Indomie, the word Indomie is something that can make it generic. I think I heard some mentors also discuss about generic of trademarks. Now, rights enjoyed by a design creator, I can decide to assign it. For instance, if I am into leather business and I'm making leather and somebody else is making the sole of a shoe, I like to use this example very well because it's happened at the office before. And there is like a conflict of interest, like an infringement or whatever, then two can come together. We have what we call administrative process. And then there's a discussion by the round table to then say, okay, why don't you, two of you like cross-license to the extent that I give you the leather that I use to make the top of the shoe, and then you give me the sole of your shoe that you make. Then I'm going to be existing maybe in the southern part of Nigeria, you are existing in the northern part of Nigeria. So this is important. Last week, I talked a lot about collaboration. Collaboration is key to any form of IP. Have an IP register, throw it under your pillow. It's doing nothing for the society. The idea behind the IP is for creativity to keep growing. It's for people to better the economy, to better the lives of people. So that is what IP is all about. And then to bring more money. Nobody cares about you having an expertise in something, or you developed something and then you bury it underground. That is not what IP. And thanks to compulsory license that government can use to grab that IP from you and give to somebody else who's ready to exploit. So we'll talk about exploitation, exports, license. You have right to sue. You also have right to surrender. You can choose to surrender to say, oh, I don't want to wait for 15 or 20 years for my patent to elapse. So I'm giving it back to the society. Like Creative Commons, which is essential under copyright. You can see someone say, I'm surrendering my IP. I know I created this fan, but I'm no longer interested in keeping it. And I don't want people to wait for 20 years. I'm throwing it open. Anybody can come and improve on my fan so that the blade turns to maybe air condition. Now, content of a design application. These are what we want to see at the office. I wouldn't want to run through them, but this particular one that talks about the novelty statement. Let's quickly look at novelty statement. This is novelty statement, just like a claim in your patent. Without your claim, you don't have a patent. And if you claim and you don't claim properly, or you don't claim broadly, you still don't have a patent. It means it can easily be attacked by anyone overnight. So you need to make your claims to be broad. But when we look at industrial design, novelty statement is the most essential part of your industrial design. What are we expecting to see? It's a detailed description of the aesthetic qualities of your products, whether it's a textile design or whether it is a product design. We want to talk about the shape. We want to talk about the patterns, if it's a material. We want to talk about the size. So you need to mention all this in detailed form. You need to talk about the color. And because we are not signatory to the Lucano agreement, we don't use what we call classification like you have in trademark, where you see NIS classification, and then we have 45 classes. Here we don't. So what it means is if you have a particular design and then that design is in different shapes or it's in different sizes, you're expected to register each and every one of those designs by their colors, their shape, and their sizes. Okay, this is another brain teaser. Because of time, I'm going to leave it. So thank you so much for your time. I hope it was worth listening to me.
Thank you so much, Ma. We sincerely do appreciate that presentation. It was wonderful. You were able to highlight some of the things that the mentors may have missed out, the other mentors may have missed out. So please, we'll be going straight to question and answers. I firstly want to apologize to both mentors and mentees on call for the amount of time we've spent in this session. We would do better to ensure that there's better time management and that we stick within the time frame that we have set. So moving on to the questions, please. Okay. Sorry, 1 minute. So there were particular questions that was sent, and we will just want to give it open to the mentors to answer some of the questions that were sent and some of the ones that are currently in the chat box. So please, I'll be reading out the questions and throwing them to the mentors that are still with us. Okay, so one of the questions here is, according to the TRIPS Article 27, Paragraph 1, all fields of technology shall have ability to be patented, but paragraph 3B gives the option stipulation to signatory states saying that saying they can essentially exclude biotechnology. This is mimicked in section 1, section 4A of the Nigerian Patents and Design Act. Why is there apparent discrimination against patenting biotechnology and medical treatments? So that's the first question. Let me look at the chat box to see which mentors we still have with us. I can see Mr. Marks. I can see Mr.
Okay.
Regina.
I can take that question. Can you hear me?
Yes, sir. We can hear you, sir. Please go ahead,
Apologies,
sir.
I'm on the move, so it might be a little bit bad. Yeah. So on that question, that issue actually is a very thorny political question. Anybody who has said about cloning, part of the fears that has led to, when the TRIPS agreement were negotiated and even up until now, is the fact that patents should not be allowed to, to encourage human beings tampering with certain essential life, issues that put on life form. So cloning, for instance, was one of the great fears in those days, that if you allow patent rights over biotechnological processes, you are essentially encouraging people to invest in patents around the issue of cloning human and animal life. So that's a huge issue. Now, one of the ways that an exception has been made to that law is plant varieties law, for instance. So under Plant Varieties Protection Act, you can actually get somewhat of some protection, almost close to patent right, over improved, say, seedlings and improved plant varieties. However, there's still a serious argument. I was watching an interview recently from Kenya where someone was complaining that the risk to Africans, for us who do a lot of subsistence farming, is that when you allow patent rights or plant variety protection, essentially you are saying that it gets to a point where only big corporates, big agricultural corporates, who typically would be foreign entities, would be the ones who get to a point where they monopolize all, seedlings and all of that. So it's a serious geopolitical question. Even up until now, it's still a serious issue that we as Africans need to take a careful look at, because we will not be able to withstand the amount of investment that Western companies can put into innovating new plant and animal varieties. And, once they do that and they get the monopoly right by way of patent or plant variety protection, it means that they can keep you out from using those improved seeds or those improved animal varieties. So it's a serious political question that we Africans should go back and really read up on, learn and understand what it's about, and be able to advocate what would best protect our own people. So that would just be my answer to that. Thank you.
All right, thank you so much, Mr. Max. We sincerely appreciate you stepping in to answer that question. We'll be going to the second question on the chat box here. It says, patent takes money to register and then to annually renew. Considering that this cost would likely be factored into the end cost, which the consumer would have to pay for medications and healthcare, should patents for the pharmaceutical and medical industries be free of charge? Okay, Miss Oyikachi, if you can you kindly help us with the answer to that question?
Sorry, do you mind rephrasing? Because I can't see it on the chat.
Okay, let me repost it so that for better highlights. Okay, it's question 2. It says, patent takes money to register and then to annually renew. Considering that this cost would likely be factored into the end cost, which the consumer would have to pay for medication and healthcare, should patents for pharmaceutical and medical industries be free of charge? Ma, are you with us? You're muted.
Yes, I am with you. I'm trying to digest the question. So I'm saying, according to TRIPS, Article 27, paragraph 1, all fields of technology shall have the ability to be patented, of course, including agriculture. But paragraph 3B gives the optional stipulation to signatory states, saying they can essentially exclude biotechnology patents. This is mimicked in section 1(4) of Nigerian Patents Act. Why is there apparent discrimination against patenting biotechnology and medical treatments? All right, for starts, patent can be granted on any field of invention. That is why one of the 3 criteria for patentability is industrially applicable. It has to be applicable to any industry whatsoever, including agriculture. However, when it comes to biotech, just like I heard something about cloning, all these things that have to do with biotech, I give you the instance of what happened in Wuhan, China, or what's the place called again? Wuhan, yeah? And then, it was in a lab, yes? And then a lot of mixtures were happening based on what people were suggesting. Something went out of hand, and then COVID was birthed. So these are some of the risk factors attached to biotechnology. However, in recent time, you also find that there are biotechnology inventions that are useful, maybe in areas like food, drugs, production, and what have you. However, for each country, because patent or any other form of IP, especially the industrial property aspects of IP, number 1 rule is this: it is territorial. So whereas the TRIPS is like a minimal protection, it suggests to each state that are signatory to it to observe a minimal standard of protection. It also gives room for states to say, I'm going to protect this, I'm not going to protect this. And one of those is the biotechnology. So in Nigeria, for instance, biotech does not fall under patentable subject matter. So before you can say you need a patent on biotech, the question is it a patentable subject matter? In fact, before you can look at a patent document, the first thing you want to know is this: is it on a patentable subject matter? If it's not, then there's no need checking, is it novel? Is it industrially applicable? Does it have inventive step? It is about the law of a country. So, but one of those reasons is essentially because back in those days, things like all this biotech can be used to corrupt the country or to corrupt the society. And I've given an instance of what happened in China with COVID. So these are some of the fears in the minds of people. I don't know if I'm supposed to take this question too. Patents take money to register and then to annually renew, considering that this cost would likely be factored into the end cost, which the customer would have to pay for medication and healthcare. Should patents for pharmaceutical and medical industries be free of charge? This is a lovely question, but the question is this: how much does it even take to register? What is the filing fee for a patent? If it is a local patent, meaning a patent owned by a Nigerian, it's just 20,000 naira. That is the filing fee. If it is a foreign patent or that of a PCT state, it is just 25,000 naira. These are the official fee we demand at the office as per what was gazetted. However, the lawyer now is whoever is drafting your patent application or whoever is filing for you or whoever the experts you're working with, because patent is not something you run off on your own. You definitely need the experts or expertise of somebody who is good in patent drafting. Like I'd mentioned, is not a moi, something you need to carry somebody along. It's now about what is this person charging. So if it's just about the 20,000 naira or the annuity, which is about 10,000 per year, how much is the paracetamol out there, for instance? Is nothing compared to the cost of these medications, especially because they come in large quantity. So I don't think the amount we are charging for registering some of these drugs or medical instruments is affecting the cost of production or affecting the cost of making those drugs available. Rather, what affects cost of production or what makes drugs not to be easily available or to be distributed to everyone is number one, the pharmaceutical industry. How good is Nigeria in that area? How many pharmaceutical companies do we have in Nigeria? How many are locally producing in Nigeria? Or do we always have to go and import? And by importing, we end up importing some fake drugs that have ended up killing children. Have we thought of using our local materials, such as all these, what do they call them now? All these, someone should help me now. All these experts, traditional medicine experts. Amongst them are people that use herbs. And most of these drugs that we import from abroad, some of them still use our locally made bitter leaf behind your father's house. They still came and took it abroad, refined it, and brought us some substances that they use to produce drugs that they will now export back to us in Nigeria, and then we import them into Nigeria and then sell them at an expensive rate. So have we thought of engaging or marrying the industry, allowing some locally made herbs or roots, and essentially the locally, what are they called now? Those traditional medicine experts in the Federal Ministry of what are they called now? Health. I know there's a department that was established around that COVID time for these local experts, traditional medicine developers. So it's high time Nigeria began to look into using our locally available herbs. Just like you have like generic drugs, like in India, they use their locally available substances to substitute those ones that have been patented. So if you look at a particular medicine substance and its component, and we feel there's a root or herb that can give essentially that, you can use it to substitute and produce locally so that people can have generic version of drugs, and that is what is going to be cheaper instead of us importing. With this exchange rates, you can see ordinary drugs or medical equipments, the rates are really skyrocketed, and poor man can't even afford medicine. Thank you.
Thank you, Ma.
Thank you very much, Ma, for that wonderful answer to those questions. I think there's one final question we'll be taking before we call it a wrap to class. And the question here will be from Miss Regina, if she's still with us. The question is, what are some common mistakes creatives make when it comes to protecting their intellectual property? Miss Regina, if you are with us, this question is directed straight to you, Ma. Can you please help us with the answer to the question? Okay. It seems Miss Regina is not here with us. So please, can we have Mr. Max help us out with that question? What are some of the common mistakes? Okay, let me look at it again. What are some of the common mistakes creatives make when it comes to protecting their intellectual property? Are you still with us, sir?
Yeah, can you hear me?
Yes, sir, we can hear you.
Okay. Yeah, that's also a good question because particularly creatives, they are always making mistakes. During the first presentation, For instance, she mentioned a couple of things, a split sheet. So if you are doing a collabo in terms of music with someone else, then you need to have a split sheet that states clearly what each person is contributing to that work and what each person's benefit would be in terms of royalty, how it would be shared, and all of that. So a lot of times creatives, the entertainers particularly, make that mistake. Of course, we all know stories about entertainers who never signed a contract, and then they get cheated later on in life, their work is exploited, and suddenly the work is used maybe in a movie, it becomes a big deal, but the guy gets nothing in return. So a lot of the mistake they make is that they do not appreciate the work of lawyers or IP experts early enough in their career. For inventors are usually more sophisticated because they are typically in industries that require a lot of research and development, and so they are typically a little bit more aware of what their rights would be and all of that. But I mean, the same advice to creatives also apply to them. They always need to get IP professionals early enough to advise them before they sign contracts. But for inventors, another very dangerous part actually is, inventors in employment. So the law is a little funny when it comes to who owns intellectual property right created in the course of employment. It can be really complicated, from a copyright point of view, from a patent point of view. Those two particularly are the most implicated IP rights in employment. But by and large, a simple barometer to use to judge it is this: if a person is employed and the nature of his employment or his schedule of duties involve that type of creative work or inventive work, then it is largely easy for the court to agree that that invention or that patent or the copyright would belong to the employer. If, however, the person is not employed in that area and he develops it, then the probability is higher that the court will find that the invention, the IP right would belong to the employee. Of course, to avoid all of these things, employment contracts should clearly stipulate about intellectual property rights so that way this kind of dispute is avoided. So that's another tip for creative and inventors, that they should always ensure there's a contract that stipulates clearly when they are in an employment relationship. So those are some of the mistakes they make, not understanding these things early enough and having clear-cut agreements that set out their rights. So that's largely what my advice would be for inventors and creatives. Thank you.
Thank you so much, sir, for helping us with that answer. So I think with this, that's sufficient for this particular class. Thank you so much to everyone who was able to wait to the end of class. I'm sure the conversation today has been very, very wonderful, and we have had quite a lot of takes on the subject matter. So please, I would like to kindly refer the mentees to this particular class back to the YouTube session, right? Because this class is being streamed on YouTube. So please, you can always refer back to the class when you have the opportunity to. Thank you so much to everyone who joined in. Thank you to all our mentors in absentia. Thank you so much to all our mentees, and to those who presented on behalf of their groups. We say well done and thank you. We look forward to seeing you in next class. We promise to give better structure for time management so that we can be done within the time frame set or allocated rather for the class. Thank you, everyone, and enjoy the rest of your evening.
Thank you.
Thank you, sir.